Resident rights. Appendix PP, Regulation Section 483.10, tags F550 through F586. Begin reading. Tag F550. Section 483.10, 0A Resident rights. The resident has a right to a dignified existence, self-determination, and communication, with an access to persons and services inside and outside the facility, including those specified in this section. Section 483.10A1, a facility must treat each resident with respect and dignity, and care for each resident in a manner and in an environment that promotes maintenance or enhancement of his or her quality of life, recognizing each resident's individuality. The facility must protect and promote the rights of the resident. Section 483.10A2, the facility must provide equal access to quality care regardless of diagnosis, severity of condition, or payment source. A facility must establish and maintain identical policies and practices regarding transfer, discharge, and the provision of services under the state plan for all residents regardless of payment source. Section 483.10, 0B Exercise of rights. The resident has the right to exercise his or her rights as a resident of the facility and as a citizen or resident of the United States. Section 483.10, 0B1, the facility must ensure that the resident can exercise his or her rights without interference, coercion, discrimination, or reprisal from the facility. Section 483.10, 0B2, the resident has the right to be free of interference, coercion, discrimination, and reprisal from the facility in exercising his or her rights, and to be supported by the facility in the exercise of his or her rights as required under this subpart. Intent Section 483.10, 0AB1 and 2. All residents have rights guaranteed to them under federal and state laws and regulations. This regulation is intended to lay the foundation for the resident rights requirements in long-term care facilities. Each resident has the right to be treated with dignity and respect. All activities and interactions with residents by any staff, temporary agency staff, or volunteers must focus on assisting the resident in maintaining and enhancing his or her self-esteem and self-worth, and incorporating the resident's goals, preferences, and choices. When providing care and services, staff must respect each resident's individuality, as well as honor and value their input. Guidance Section 483.10, 0AB1 and 2. Examples of treating residents with dignity and respect include, but are not limited to, encouraging and assisting residents to dress in their own clothes rather than hospital type gowns, and appropriate footwear for the time of day and individual preferences. Placing labels on each resident's clothing in a way that is inconspicuous and respects his or her dignity, for example, placing labeling on the inside of shoes and clothing, or using a color coding system. Promoting resident independence and dignity while dining, such as avoiding daily use of disposable cutlery and dishware. Bibs or clothing protectors instead of napkins, except by resident choice. Staff standing over residents while assisting them to eat. Staff interacting/conversing only with each other rather than with residents while assisting with meals. Protecting and valuing residents' private space, for example, knocking on doors and requesting permission before entering, closing doors as requested by the resident. Staff should address residents with the name or pronoun of the resident's choice. Avoiding the use of labels for residents such as feeders or walkers. Residents should not be excluded from conversations during activities or when care is being provided, nor should staff discuss residents in settings where others can overhear private or protected information or document in charts/electronic health records, where others can see a resident's information. Refraining from practices demeaning to residents, such as leaving urinary catheter bags uncovered, refusing to comply with a resident's request for bathroom assistance during meal times, and restricting residents from use of common areas open to the general public, such as lobbies and restrooms, unless they are on transmission-based isolation precautions or are restricted according to their care plan needs. Consider the resident's lifestyle and personal choices identified through their assessment processes to obtain a picture of his or her individual needs and preferences. Staff and volunteers must interact with residents in a manner that takes into account the physical limitations of the resident, assures communication, and maintains respect. For example, getting down to eye level with a resident who is sitting, maintaining eye contact when speaking with a resident with limited hearing, or utilizing a hearing amplification device when needed by a resident. Pay close attention to resident or staff interactions that may represent deliberate actions to limit a resident's autonomy or choice. These actions may indicate abuse. See F600, Free from Abuse. For guidance, the facility must not establish policies or practices that hamper, compel, treat differently, or retaliate against a resident for exercising his or her rights. Justice-involved residents. Justice-involved residents includes the following three categories. 1. Residents under the care of law enforcement. Residents who have been taken into custody by law enforcement. Law enforcement includes local and state police, sheriffs, federal law enforcement agents, and other deputies charged with enforcing the law. 2. Residents under community supervision. Residents who are on parole, on probation, or required to conditions of ongoing supervision and treatment as an alternative to criminal prosecution by a court of law. 3. Inmates of a public institution. Residents currently in custody and held involuntarily through operation of law enforcement authorities in an institution, which is the responsibility of a governmental unit, or over which a governmental unit exercises administrative control, such as state or federal prisons, local jails, detention facilities, or other penal settings such as boot camps, wilderness camps. Justice-involved individuals are entitled to the same rights described in 42 CFR Part 483, Subpart B as all other residents residing in the facility. The facility shall not establish policies or impose conditions on the justice-involved resident that result in restrictions which violate the resident's rights. Some Department of Corrections or law enforcement terms of release or placement may conflict with CMS requirements if the facility accepts responsibility for enforcing restrictive law enforcement terms applied to a resident that are contrary to the requirements for LTC facilities. The facility would not be in compliance with federal long-term care requirements. In addition, law enforcement jurisdictions may not be integrated with the operations of the facility. While all portions of 42 CFR Part 483, Subpart B, apply to justice-involved individuals, other areas where there may be concerns specific to this population are found at Section 483.12, F600, Abuse, Neglect and Exploitation, and Section 483.15C, F622, Transfer and Discharge. In such a case, surveyors should cite under the specific tag associated with the concern identified. For example, if there is a concern about a facility restricting visitors of a justice-involved individual, cite such deficiency under Section 483.10 F4 Roman 6, F564, Resident Right to Visitors. See Survey and Certification Memorandum, 16 to 21 all, dated May 3, 2016, revised 12/23/16/4. Additional guidance on justice involved individuals. Procedures Section 483.1, 0AB1 and 2. Deficient practices, cited under resident rights tags, may also have negative psychosocial outcomes for the resident. The survey team must consider the potential for both physical and psychosocial harm when determining the scope and severity of deficiencies related to dignity. Refer to the Psychosocial Outcome Severity Guide in Appendix P. Surveyors shall make frequent observations on different shifts, units, floors, or neighborhoods too. Watch interactions between and among residents and staff. If there are concerns that staff, others are not treating a resident with dignity or respect, or are attempting to limit a resident's autonomy or freedom of choice, follow up as appropriate by interviewing the resident, family, or resident representative. Observe if staff show respect for each resident and treat them as an individual. Do staff respond in a timely manner to the resident's requests for assistance? Do staff explain to the resident what care is being provided or where they are taking the resident? Is the resident's appearance consistent with his or her preferences and in a manner that maintains his or her dignity? Do staff know the resident's specific needs and preferences? Do staff make efforts to understand the preferences of those residents who are not able to verbalize them due to cognitive or physical limitations? Determine if staff members respond to residents with cognitive impairments in a manner that facilitates communication and allows the resident the time to respond appropriately. 4. Example, a resident with dementia may be attempting to exit the building with the intent to meet her/his children at the school bus, walking with the resident without challenging or disputing the resident's intent, and conversing with the resident about the desire. Tell me about your children may reassure the resident in a manner consistent with the requirements of Section 483.10a and b. Examples of noncompliance may include, but are not limited to, a resident has not been treated equally as compared to others based on his or her diagnosis, severity of condition, or payment source. Prohibiting a resident from participating in group activities as a form of reprisal or discrimination. This includes prohibiting a resident from group activities without clinical justification or evaluation of the impact the resident's participation has on the group. A resident's rights, not addressed elsewhere, for example, religious expression, voting, or freedom of movement outside the facility, in the absence of a legitimate clinical need, are impeded in some way by facility staff. Requiring residents to seek approval to post, communicate, or distribute information about the facility, for example, social media, letters to the editor of a newspaper. Acting on behalf of the pertinent law enforcement or criminal justice supervisory authority by enforcing supervisory conditions or reporting violations of those conditions to officials for justice involved residents. Potential tags for additional investigation. For deficiencies regarding lack of visual privacy for a resident while that resident is receiving treatment or ADL, care from staff in the bedroom, bathroom, or bathing room, refer to Section 483.10e, F583, Privacy and Confidentiality. For deficiencies regarding a resident's lack of self-determination to make decisions about things that are important in his or her life, refer to Section 483.10 F13, 8, F561, Self-determination. For deficiencies related to failure to keep residents' faces, hands, teeth, fingernails, hair, and clothing clean, refer to Section 483.24a2, F677, Activities of Daily Living Adults. if there are indications that a resident is in a secured/locked area without a clinical justification, and or placement is against the will of the resident, their family, and or resident representative. Review regulatory requirements at Section 483.12 and Section 483.12a, F603, involuntary seclusion. Tag F551. Section 483.10 0b3, in the case of a resident who has not been adjudged incompetent by the state court, the resident has the right to designate a representative in accordance with state law, and any legal surrogate so designated may exercise the resident's rights to the extent provided by state law. The same-sex spouse of a resident must be afforded treatment equal to that afforded to an opposite-sex spouse if the marriage was valid in the jurisdiction in which it was celebrated. The resident representative, has the right to exercise the resident's rights to the extent those rights are delegated to the representative. Roman 2, the resident retains the right to exercise those rights not delegated to a resident representative, including the right to revoke a delegation of rights, except as limited by state law. Section 483.10 0b4, the facility must treat the decisions of a resident representative as the decisions of the resident to the extent required by the court or delegated by the resident, in accordance with applicable law. Section 483.10 0b5, the facility shall not extend the resident representative the right to make decisions on behalf of the resident beyond the extent required by the court or delegated by the resident in accordance with applicable law. Section 483.10 0b6, if the facility has reason to believe that a resident representative is making decisions or taking actions that are not in the best interests of a resident, the facility shall report such concerns when and in the manner required under state law. Section 483.10 0b7, in the case of a resident adjudged incompetent under the laws of a state by a court of competent jurisdiction, the rights of the resident devolve to and are exercised by the resident representative appointed under state law to act on the resident's behalf. The court-appointed resident representative exercises the resident's rights to the extent judged necessary by a court of competent jurisdiction in accordance with state law. In the case of a resident representative whose decision-making authority is limited by state law or court appointment, the resident retains the right to make those decisions outside the representative's authority. Roman 2, the resident's wishes and preferences must be considered in the exercise of rights by the representative. Roman 3, to the extent practicable, the resident must be provided with opportunities to participate in the care planning process. Definitions, Section 483.10 0b37. Court of competent jurisdiction means any court with the authority to hear and determine a case or suit with the matter in question. Resident representative, for purposes of this subpart, the term resident representative may mean any of the following. 1. An individual chosen by the resident to act on behalf of the resident in order to support the resident in decision-making, access medical, social, or other personal information of the resident, manage financial matters, or receive notifications. 2. A person authorized by state or federal law, including, but not limited to, agents under power of attorney, representative payees, and other fiduciaries to act on behalf of the resident in order to support the resident in decision-making, access medical, social, or other personal information of the resident, manage financial matters, or receive notifications, or 3. Legal representative, as used in Section 712 of the Older Americans Act, or 4. the court-appointed guardian or conservator of a resident. 5. Nothing in this rule is intended to expand the scope of authority of any resident. Representative beyond that authority, specifically authorized by the resident, state, or federal law, or a court of competent jurisdiction. Guidance Section 483.10b37. When reference is made to resident in the guidance, it also refers to any person who may, under state law, act on the resident's behalf when the resident is unable to act for themselves. That person is referred to as the resident representative if the resident has been formally declared incompetent by a court. The representative is whomever the court appoints, for example, a guardian or conservator. A competent resident may wish to delegate decision-making to specific persons, or the resident and family may have agreed among themselves on a decision-making process. To the degree permitted by state law, the facility staff must respect the delegated resident representatives' decisions regarding the resident's wishes and preferences so long as the resident representative is acting within the scope of authority contemplated by the agreement authorizing the person to act as the resident's representative. In the case of a resident who has been formally declared incompetent by a court appointed resident representative may be assigned. Facility staff must confer with the appointed resident representative. State laws and court orders authorizing guardians, conservators, etc. vary considerably. Many statutes and court orders limit the scope of the authority of the representative to act on behalf of the resident. Facility staff must obtain documentation that the resident's representative has been delegated the necessary authority to exercise the resident's rights and must verify that a court-appointed representative has the necessary authority for the decision-making at issue as determined by the court. For example, a court-appointed representative might have the power to make financial decisions, but not health care decisions. Additionally, the facility must make reasonable efforts to ensure that it has access to documentation of any change related to the delegation of rights, including a resident's revocation of delegated rights, to ensure that the resident's preferences are being upheld. Whether a resident has or has not been judged incompetent by a court of law, if it is determined that the resident understands the risks, benefits, and alternatives to proposed health care and expresses a preference, then the resident's wishes should be considered to the degree practicable, including resident input into the care planning process. The involvement of a representative does not relieve facility staff of their duty to protect and promote the resident's interests. For example, a representative does not have the right to insist that treatment be performed that is not medically appropriate or reject a treatment that may be subject to state law. Surveyors must confirm delegation of resident rights to a resident representative. Surveyors must also determine, through interview and record reviews, whether or not the resident's delegation of rights has been followed by facility staff. If a resident's representative is a same-sex spouse, he or she must be treated the same as an opposite-sex spouse with regard to exercising the resident's rights. In Obergefell LV, Hodges, 576. U.S. 2015, the Supreme Court of the United States also ruled that all states must recognize a marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. Procedures Section 483.10b37. Surveyors must check whether there has been a delegation of resident rights or designation of a resident representative. Surveyors must also determine, through interview and record reviews, whether or not the resident's delegation of rights has been followed by facility staff. Determine, through interview and record review, if the resident has been found to be legally Incompetent by a court in accordance with state law. If yes, verify the appropriate legal documentation for a court-appointed resident representative is present in the resident's medical record. Review court orders or other legal documentation to determine the extent of the court. Appointed resident representative's authority to make decision on behalf of the resident, and any limitations on that authority that may have been ordered by the court. Determine if the court-appointed representative is making decisions for the resident beyond the scope of the resident representative's decision-making authority, and the facility is relying on that authority as the basis of a practice, e.g., healthcare treatment, managing resident funds, discharge decision. If so, a deficiency may be cited under this regulation. Determine if the resident was involved in care planning activities and able to make choices to the extent possible. Observe resident care and daily activities, e.g., participation in activities for adherence to residents' or court-appointed resident representatives' goals, choices, and preferences. Even when there is a court-appointed resident representative, the facility should seek to understand the resident's goals, choices, and preferences, and have honored them to the extent legally possible. If no, determine how decisions are being made for the resident. Does the resident maintain all of his or her rights, even if he/she has designated a representative to assist with decision making, unless a court has limited those rights under state law, and only to the extent that has been specified by a court under state law? Has the resident designated a resident representative and his facility staff, respecting the authority of this designate surrogate decision maker to act on behalf of the resident? Are all residents informed of their plan of care or treatment in the most understandable manner possible and given an opportunity to voice their views? Autonomy is also expressed through gestures and actions, and this also should be recognized. Residents, even without capacity or declared incompetent, may be able to express their needs and desires. Determine whether same-sex spouses are treated in the same manner as an opposite-sex spouse in all states and territories. If the resident has delegated a resident representative, verify the appropriate documentation is present in the resident's medical record. Key elements of noncompliance section 483.10b37. To cite deficient practice at F551, the surveyor's investigation will generally show that the facility failed to do any one or more of the following: ensure a competent resident's choice for a representative is honored, or ensure that treatment of a same-sex spouse was the same as treatment of an opposite-sex spouse, or ensure the resident representative did not make decisions beyond the extent allowed by the court or delegated by the resident, or ensure the resident's wishes and preferences were considered when decisions were made by the resident representative, or ensure the decisions of the resident representative are given the same consideration as if the resident made the decision themselves, or honor the resident's authority to exercise his or her rights, even when he or she has delegated those rights, including the right to revoke a delegation of rights, or ensure the resident representative was reported as state law required when not acting in the best interest of the resident, or ensure a resident who was found incompetent by the court is provided with opportunities to participate in the care planning process. Tag F552. Section 483.10c, Planning and Implementing Care. The resident has the right to be informed of and participate in his or her treatment, including Section 483.10c1, the right to be fully informed in language that he or she can understand of his or her total health status, including but not limited to his or her medical condition. Section 483.1, 0C4 the right to be informed, in advance, of the care to be furnished and the type of caregiver or professional that will furnish care. Section 483.1, 0C5 the right to be informed in advance, by the physician or other practitioner or professional, of the risks and benefits of proposed care, of treatment and treatment, alternatives or treatment options, and to choose the alternative or option he or she prefers. Definitions Section 483.1, 0C1, 45. Total health status includes functional status, nutritional status, rehabilitation and restorative potential, ability to participate in activities, cognitive status, oral health status, psychosocial status, and sensory and physical impairments. Treatment refers to medical care, nursing care, and interventions provided to maintain or restore health and well-being, improve functional level, or relieve symptoms. Guidance Section 483.10C1, 45. Health information and services must be provided in ways that are easy for the resident or the resident's representative to understand. This includes, but is not limited to, communicating in plain language, explaining technical and medical terminology in a way that makes sense to the resident, offering language assistance services to residents who have limited English proficiency, and providing qualified sign language interpreters or auxiliary aids if hearing is impaired. This does not mean that a facility is required to supply and pay for hearing aids. The physician or other practitioner or professional must inform the resident or their representative in advance of treatment risks and benefits, options, and alternatives. The information should be communicated at times it would be most useful to them, such as when they are expressing concerns, raising questions, or when a change in treatment is being proposed. The resident or resident representative has the right to choose the option he or she prefers. Discussion and documentation of the resident's choices regarding future health care may take place during the development of the initial comprehensive assessment and care plan and periodically thereafter. Note, while surveyors must only cite F552 when deficient practice is found related to applicable program requirements as reflected in the CFR, the following information may inform surveyors about important considerations in making compliance decisions. The Federal Patient Self-Determination Act, contained in Public Law 101 to 508, is the authority on an individual's rights and facility responsibilities related to advance directives. This includes the right of an individual to direct his or her own medical treatment, including withholding or withdrawing life-sustaining treatment, if there are concerns with advance directives. Refer to Section 483.10 G12, F578. See Section 483.21A, F655 Baseline Care Plans, Comprehensive Person-Centered Care Planning, 4. Additional guidance. Tag F553. Section 483.1. 0C2 the right to participate in the development and implementation of his or her person-centered plan of care, including but not limited to I. The right to participate in the planning process, including the right to identify individuals or roles to be included in the planning process, the right to request meetings, and the right to request revisions to the person-centered plan of care. Roman 2. The right to participate in establishing the expected goals and outcomes of care, the type, amount, frequency, and duration of care, and any other factors related to the effectiveness of the plan of care. Roman 3. The right to be informed in advance of changes to the plan of care. Roman 4, the right to receive the services and / or items included in the plan of care. V, the right to see the care plan, including the right to sign after significant changes to the plan of care. Section 483.1, 0C3, the facility shall inform the resident of the right to participate in his or her treatment and shall support the resident in this right. The planning process must I. Facilitate the inclusion of the resident and / or resident representative. Roman 2, include an assessment of the resident's strengths and needs. Roman 3, incorporate the resident's personal and cultural preferences in developing goals of care. Intent Section 483.1, 0C23. To ensure facility staff facilitates the inclusion of the resident or resident representative in all aspects of person-centered care planning, and that this planning includes the provision of services to enable the resident to live with dignity and supports the resident's goals, choices, and preferences including, but not limited to, goals related to their daily routines and goals to potentially return to a community setting. Guidance Section 483.1, 0C23. Residents and their representatives must be afforded the opportunity to participate in their care planning process and to be included in decisions and changes in care, treatment, and / or interventions. This applies both to initial decisions about care and treatment, as well as the refusal of care or treatment. Facility staff must support and encourage participation in the care planning process. This may include ensuring that residents, families, or representatives understand the comprehensive care planning process, holding care planning meetings at the time of day when a resident is functioning best, providing sufficient notice in advance of the meeting, scheduling these meetings to accommodate a resident's representative, such as conducting the meeting in person, via a conference call or video conferencing, and planning enough time for information exchange and decision-making. A resident has the right to select or refuse specific treatment options before the care plan is instituted, based on the information provided as required under Section 483.10C1, 45, F552. While federal regulations affirm a resident's right to participate in care planning and to refuse treatment, the regulations do not require the facility to provide specific medical interventions or treatments requested by the resident, family, and / or resident representative that the resident's physician deems inappropriate for the resident's medical condition. A resident whose ability to make decisions about care and treatment is impaired, or a resident who has been declared incompetent by a court, must, to the extent practicable, be kept informed and be consulted on personal preferences. The resident has the right to see the care plan and sign after significant changes are made. Procedures Section 483.1, 0C23. During observations, interviews, and record reviews, surveyors must interview the resident and / or his or her representative to determine the level of participation in care planning. Identify ways staff involve residents and / or their representatives in care planning. Determine if care plan meetings are scheduled to accommodate residents and / or their representative. Determine how facility staff addressed questions or concerns raised by a resident or his or her representative, including if they are addressed at times when it would be beneficial to the resident, such as when they are expressing concerns or raising questions. Determine if the resident and representative were unable to participate, did facility staff consult them in advance about care and treatment changes. Interview staff to determine how they inform residents or their representative of their rights and incorporate their personal preferences, choices, and goals into their care plan. when the resident request is something that facility staff feels would place the individual at risk, i.e., the resident chooses not to use the walker recommended by therapy. Is there a process in place to examine the risk/benefit and guide decision-making? Review the resident's medical record to determine if facility staff included an assessment of the resident's strengths and needs and whether these, as well as the resident's personal and cultural preferences, were incorporated when developing his or her care plan. Determine how facility staff observes and responds to the nonverbal communication of a resident who is unable to verbalize preferences, i.e., if the resident spits out food, is this considered to be a choice and alternative meal options offered? Potential tags for additional consideration. If facility staff do not provide access to the care plan within 24 hours, excluding weekends and holidays, or provide, if requested, a copy of the care plan in written or electronic form within 2 working days of the request, see Section 483.10G23, F573, right to access/purchase copies of records. If facility staff do not provide a summary of the baseline care plan to the resident and their representative, see Section 483.21A, F655, Baseline Care Plans. Also refer to Section 483.21B, F656, Comprehensive Care Plans for more information on care plans. Tag F554. Section 483.10C7, the right to self-administer medications if the interdisciplinary team, as defined by Section 483.21B2 Roman 2, has determined that this practice is clinically appropriate. Guidance Section 483.10C7. If a resident requests to self-administer medication it is the responsibility of the interdisciplinary team, IT, as defined in Section 483.21B, F657, Comprehensive Care Plans, to determine that it is safe before the resident exercises that right. A resident may only self-administer medications after the IDT has determined which medications may be self-administered. When determining if self-administration is clinically appropriate for a resident, the IDT should, at a minimum, consider the following: the medications appropriate and safe for self-administration, the resident's physical capacity to swallow without difficulty and to open medication bottles, the resident's cognitive status, including their ability to correctly name their medications and know what conditions they are taken for, the resident's capability to follow directions and tell time to know when medications need to be taken, the resident's comprehension of instructions for the medications they are taking, including the dose, timing, and signs of side effects, and when to report to facility staff, the resident's ability to understand what refusal of medication is and appropriate steps taken by staff to educate when this occurs, the resident's ability to ensure that medication is stored safely and securely. Appropriate notation of these determinations must be documented in the resident's medical record and care plan. If a resident is self-administering medication, review the resident's record to verify that this decision was made by the IDT, including the resident. The decision that a resident has the ability to self-administer medication is subject to periodic assessment by the IT based on changes in the resident's medical and decision-making status. If self-administration is determined not to be safe, the IDT should consider, based on the assessment of the resident's abilities, options that allow the resident to actively participate in the administration of their medications to the extent that is safe, i.e., the resident may be assessed as not able to self-administer their medications because they are not able to manage a locked box in their room. But they may be able to get the medications from the nurse at a designated location and then safely self-administer them. Medication errors occurring with residents who self-administer should not be counted in the facility's medication error rate and should not be cited at Section 483.4, 5F1 F759, and Section 483.4, 5F2. F760, medication errors. However, this may call into question the judgment of facility staff in allowing self-administration of medication for that resident. Procedures and Probes Section 483.1, 0C7. Determine that facility staff have a process to demonstrate that the resident has taken the self-administered medication. Ask residents if they requested to self-administer medications and if they received a response. How do staff determine if a resident is able to safely self-administer medications? If the interdisciplinary team has determined that the resident can safely self-administer medications, was this request honored? If the interdisciplinary team was not involved in determining whether the self-administration of medications was clinically appropriate, cite here at F554. If other concerns related to care planning are identified, see guidance at Section 483.21, Comprehensive Person-Centered Care Planning. Tag F555. Section 483.1, 0D, Choice of Attending Physician. The resident has the right to choose his or her attending physician. Section 483.1, 0D1, the physician must be licensed to practice, and Section 483.1, 0D2, if the physician chosen by the resident refuses to or does not meet requirements specified in this part, the facility may seek alternate physician participation. As specified in paragraphs D4 and 5 of this section to assure provision of appropriate and adequate care and treatment. Section 483.1, 0D3, the facility must ensure that each resident remains informed of the name, specialty, and way of contacting the physician and other primary care professionals responsible for his or her care. Section 483.1, 0D4, the facility must inform the resident if the facility determines that the physician chosen by the resident is unable or unwilling to meet requirements specified in this part, and the facility seeks alternate physician participation to assure provision of appropriate and adequate care and treatment. The facility must discuss the alternative physician participation with the resident and honor the resident's preferences, if any, among options. Section 483.1, 0D5, if the resident subsequently selects another attending physician who meets the requirements specified in this part, the facility must honor that choice. Definitions, Section 483.1, 0D15. Attending physician refers to the primary physician who is responsible for managing the resident's medical care. This does not include other physicians whom the resident may see periodically, such as specialists. Guidance Section 483.1, 0D15. The right to choose a personal physician does not mean that a resident is required to do so. It also does not mean that the physician the resident chose is obligated to provide service to the resident. If a resident or his or her representative declines to designate a personal physician, or if a physician of the resident's choosing fails to fulfill their responsibilities, as specified in Section 483.30, F710, physician services, or elsewhere as required in these regulations, facility staff may choose another physician after informing the resident or the resident's representative. Before consulting an alternate physician, the medical director must have a discussion with the attending physician. Only after a failed attempt to work with the attending physician or mediate differences may facility staff request an alternate physician. Facility staff may not interfere in the process by which a resident chooses his or her physician. If a resident does not have a physician, or if the resident's physician becomes unable or unwilling to continue providing care to the resident, facility staff must assist the resident or the resident's representative in finding a replacement. If it is a condition for admission to a nursing home contained within a continuing care retirement community CCRC, the requirement for free choice is met if a resident chooses a personal physician from among those who have practice privileges at the CCRC. A resident in a distinct part of a general acute care hospital may choose his or her own physician. If the hospital requires that physicians who supervise residents in the distinct part have privileges, then the resident cannot choose a physician who lacks them. Probe Section 483.1, 0D15. Through interviews with facility staff and residents or their representatives, determine how residents or their representative are informed of and are supported in his or her right to choose a physician. How to contact their physician and other primary care professionals responsible for their care. His or her options to choose an alternate physician or other primary care professional. If his or her physician is unable or not willing to provide necessary care and services, determine if facility staff worked with the resident to choose another physician. Tag F556. This tag number is in reserve for future use, and there will be no citations under this tag. Tag F557. Section 483.1, 0E, Respect and Dignity. The resident has a right to be treated with respect and dignity, including Section 483.1, 0E2, the right to retain and use personal possessions, including furnishings and clothing, as space permits, unless to do so would infringe upon the rights or health and safety of other residents. Intent Section 483.1, 0E2. All residents' possessions, regardless of their apparent value to others, must be treated with respect. Guidance Section 483.10 E2. The right to retain and use personal possessions promotes a home-like environment and supports each resident in maintaining their independence. If residents' rooms have few personal possessions, ask residents, their families, or representatives, as well as the local ombudsman if residents are encouraged to have and to use them, and residents may choose to retain personal possessions. Procedures Section 483.10 E2. If facility staff refused to allow a resident to retain his or her personal possessions, determine if such a restriction was appropriate due to insufficient space, protection of health and safety, and maintaining other resident rights, and whether the reason for the restriction was communicated to the resident. Examples of noncompliance may include, but are not limited to, residents, their representatives, or family members have been discouraged from bringing personal items to the facility. A decision to refuse to allow a resident to retain any personal belongings was not based on space limitations or on a determination that the rights, health, or safety of other residents would be infringed. Facility staff searching a resident's body or personal possessions without the resident's, or, if applicable, the resident's representative's consent. It is important for facility staff to have knowledge of signs, symptoms, and triggers of possible illegal substance use, such as changes in resident behavior, increased unexplained drowsiness, lack of coordination, slurred speech, mood changes, and or loss of consciousness, etc. This may include asking residents who appear to have used an illegal substance, e.g., cocaine, hallucinogens, heroin, whether or not they possess or have used an illegal substance. If the facility determines through observation that a resident may have access to illegal substances that they have brought into the facility or secured from an outside source, the facility should not act as an arm of law enforcement. Rather, in accordance with state laws, these cases may warrant a referral to local law enforcement to protect the health and safety of residents. Facilities may need to provide additional monitoring and supervision if facility staff identify items or substances that pose risks to residents' health and safety and are in plain view. They may confiscate them, but facility staff should not conduct searches of a resident or their personal belongings unless the resident or resident representative agrees to a voluntary search and understands the reason for the search, for concerns related to the identification of risk and the provision of supervision to prevent accidental overdose. Investigate potential noncompliance at F689, Section 483.2, 5D, accidents. For concerns related to the behavioral health services that are provided, investigate potential non-compliance at F740, Section 483.40, behavioral health services. Tag F558. Section 483.10, 0E3, the right to reside and receive services in the facility with reasonable accommodation of resident needs and preferences, except when to do so would endanger the health or safety of the resident or other residents. Intent Section 483.10 E3. The accommodation of resident needs and preferences is essential to creating an individualized, home-like environment. Definitions, Section 483.10 E3. Reasonable accommodation of resident needs and preferences means the facility's efforts to individualize the resident's physical environment. Guidance Section 483.10 E3. Reasonable accommodation of resident needs and preferences includes, but is not limited to, individualizing the physical environment of the resident's bedroom and bathroom, as well as individualizing common living areas as much as feasible. These reasonable accommodations may be directed toward assisting the resident in maintaining and or achieving independent functioning, dignity, and well-being to the extent possible in accordance with the resident's own needs and preferences. The environment must reflect the unique needs and preferences of each resident to the extent reasonable and does not endanger the health or safety of individuals or other residents. Common areas frequented by residents should accommodate residents' physical limitations. Furnishings in common areas may enhance residents' abilities to maintain their independence. Resident seating should have appropriate seat height, depth, firmness, and with arms that assist residents to independently rise to a standing position. Functional furniture must be arranged to accommodate residents' needs and preferences. Procedures Section 483.10 E3. Observe residents in their rooms and common areas and interview residents, if possible, to determine if their environment accommodates their needs and preferences. Observe staff/resident interactions to determine if staff interact in a manner that a resident with limited sight or hearing can see and hear them. Determine if staff keep needed items within the resident's reach and provide necessary assistance to help maintain the resident's independence. Determine if the resident has the call system within reach and is able to use it if desired. Examples of noncompliance may include, but are not limited to, storing a wheelchair or other adaptive equipment out of reach of a resident who is otherwise able to use them independently, such as a wheelchair stored across the room. For a resident, who is able to self-transfer or storing eyeglasses out of reach for a resident. Having areas of worship inaccessible to residents with mobility limitations. Not providing a riser on a toilet to maintain independence. Tag F559. Section 483.1. 0E4 the right to share a room with his or her spouse when married residents live in the same facility and both spouses consent to the arrangement. Section 483.1. 0E5 the right to share a room with his or her roommate of choice when practicable, when both residents live in the same facility and both residents consent to the arrangement. Section 483.1. 0E6 the right to receive written notice, including the reason for the change, before the resident's room or roommate in the facility is changed. Guidance Section 483.1. 0E46. Residents have the right to share a room with whomever they wish, as long as both residents are in agreement. These arrangements could include opposite-sex and same-sex married couples or domestic partners, siblings, or friends. There are some limitations to these rights. Residents do not have the right to demand that a current roommate is displaced in order to accommodate the couple that wishes to room together. In addition, residents are not able to share a room if one of the residents has a different payment source for which the facility is not certified if the room is in a distinct part of the facility, unless one of the residents elects to pay privately for his or her care, or one of the individuals is not eligible to reside in a nursing home. Moving to a new room or changing roommates is challenging for residents. A resident's preferences should be taken into account when considering such changes. When a resident is being moved at the request of facility staff, the resident, family, and or resident representative must receive an explanation in writing of why the move is required. The resident should be provided the opportunity to see the new location, meet the new roommate, and ask questions about the move. A resident receiving a new roommate should be given as much advance notice as possible. The resident should be supported when a roommate passes away by providing time to adjust before moving another person into the room. The length of time needed to adjust may differ depending upon the resident. Facility staff should provide necessary social services for a resident who is grieving over the death of a roommate. If the survey team identifies potential compliance issues related to social services, refer to Section 483.40D, F745, Social Services. Tag F560. Section 483.1. 0E7, the right to refuse to transfer to another room in the facility, if the purpose of the transfer is to relocate a resident of a SNF from the distinct part of the institution that is a SNF to a part of the institution that is not a SNF, or Roman 2, to relocate a resident of a NF from the distinct part of the institution that is a NF to a distinct part of the institution that is a SNF. Roman 3, solely for the convenience of staff. Section 483.1. 0E8, a resident's exercise of the right to refuse transfer does not affect the resident's eligibility or entitlement to Medicare or Medicaid benefits. Definitions, Section 483.1. 0E78. Campus, under Section 413.6, 5A2. Campus means the physical area immediately adjacent to the provider's main buildings, other areas and structures that are not strictly contiguous to the main buildings but are located within 250 yards of the main buildings, and any other areas determined on an individual case basis by the CMS regional office to be part of the provider's campus. Composite distinct part. Under Section 483.5, a composite distinct part is a type of distinct part SNF or NF, consisting of two or more non-contiguous components that are not located within the same campus, as that term is defined in Section 413.65A2. Distinct part. A distinct part SNF or NF is part of a larger institution or institutional complex. The distinct part SNF or NF is physically distinguishable from the larger institution or complex and may be comprised of one or more buildings or parts of buildings such as wings, wards, or floors. Distinct part SNFs or NFs must be immediately adjacent or in close proximity to the institution's main buildings. CMS may determine on an individual basis that other areas are part of the institution's campus and considered to be a distinct part SNF or NF. A distinct part SNF or NF must include all of the beds within the designated area and cannot consist of a random collection of individual rooms or beds that are scattered throughout the physical plant. The term distinct part also includes composite distinct part SNFs or NFs. Additional requirements specific to distinct part SNFs or NFs are found at Section 483.5. Guidance Section 483.10 E78. A resident can decline relocation from a room in one institution's distinct part SNF or NF to a room in another institution's distinct part SNF or NF for purposes of obtaining Medicare or Medicaid eligibility. Facility staff are responsible for notifying the resident or resident representative of changes in eligibility for Medicare or Medicaid covered services and of what the resident's financial responsibility may be if the resident is unable to pay for those services. Then, after giving the resident a discharge notice, the resident may be transferred or discharged. Under the provisions of Section 483.15b, F621, equal access to quality care. When a resident occupies a bed in a distinct part NF that is certified to participate in Medicaid only and not in Medicare, he or she may not be moved involuntarily or required to be moved by the state from that distinct part NF to another part of the larger institution, e.g., hospital or intermediate care facility for individuals with intellectual disabilities that houses the distinct part, solely for the purpose of assuring eligibility for Medicare payments. Such moves are only appropriate only when they occur at the request of a resident. A resident also has the right to refuse transfer if that transfer is solely for the convenience of staff. For example, a resident may experience a change in condition that requires additional care. Facility staff may wish to move the resident to another room with other residents who require a similar level of services because it is easier for staff to care for residents with similar needs. The resident would have the right to stay in his or her room and refuse this transfer. Probes Section 483.10 E78. For residents moved between Medicare or Medicaid approved distinct parts. Was the resident moved to a different room because of a change in payment source or staff convenience? Did facility staff give the resident the opportunity to refuse the transfer? Potential tags for additional consideration. Section 42, CFR Section 483.10 E6, F559, Notification of Roommate Change. O. Determine if the resident received prior notification of a room change. Section 42, CFR Section 483.10 G17, F582, Medicare/Medicaid coverage. O. Determine if the resident was notified of changes in eligibility for Medicare or Medicaid covered services, what the resident's financial responsibility may be, and their appeal rights. For additional guidance regarding admission to, discharges, or transfers from a SNF or NF, including bed hold policies and therapeutic leave. See Section 483.15, F620 admission, transfer, and discharge rights. Tag F561. Section 483.10, 0F, self-determination. The resident has the right to, and the facility must promote and facilitate resident self-determination through support of resident choice, including but not limited to the rights specified in paragraphs F1 through 11 of this section. Section 483.10 F1, the resident has a right to choose activities, schedules including sleeping and waking times, health care and providers of health care services consistent with his or her interests, assessments, and plan of care and other applicable provisions of this part. Section 483.10 F2, the resident has a right to make choices about aspects of his or her life in the facility that are significant to the resident. Section 483.10 F3, the resident has a right to interact with members of the community and participate in community activities both inside and outside the facility. Section 483.10 F8, the resident has a right to participate in other activities, including social, religious, and community activities that do not interfere with the rights of other residents in the facility. Intent Section 483.10 F13 and 8. The intent of this requirement is to ensure that each resident has the opportunity to exercise his or her autonomy regarding those things that are important in his or her life. This includes the resident's interests and preferences. Guidance, Section 483.10 F13, 8. It is important for residents to have a choice about which activities they participate in, whether they are part of the formal activities program or self-directed. Additionally, a resident's needs and choices for how he or she spends time, both inside and outside the facility, should also be supported and accommodated to the extent possible, including making transportation arrangements. Residents have the right to choose their schedules consistent with their interests, assessments, and care plans. This includes, but is not limited to, choices about the schedules that are important to the resident, such as waking, eating, bathing, and going to bed at night. Choices about schedules and ensuring that residents are able to get enough sleep is an important contributor to overall health and well-being. Residents also have the right to choose healthcare schedules consistent with their interests and preferences, and information should be gathered to proactively assist residents with the fulfillment of their choices. Facilities must not develop a schedule for care, such as waking or bathing schedules, for staff convenience and without the input of the residents. Examples that demonstrate the support and accommodation of resident goals, preferences, and choices include, but are not limited to, if a resident shares that attendance at family gatherings or external community events is of interest to them, the resident's goals of attending these events should be accommodated to the extent possible. If a resident mentions that his or her therapy is scheduled at the time of a favorite television program, the resident's preference should be accommodated to the extent possible. If a resident refuses a bath because he or she prefers a shower or a different bathing method, such as in-bed bathing, prefers to bathe at a different time of day or on a different day, does not feel well that day, is uneasy about the aid assigned to help, or is worried about falling, the resident's preferences must be accommodated. If a facility changes its policy to prohibit smoking, including electronic cigarettes, it should allow current residents who smoke to continue smoking in an area that maintains the quality of life for these residents and takes into account non-smoking residents. The smoking area may be An outside area provided that residents remain safe. Residents admitted after the facility changes. Its policy must be informed of this policy at admission. See Section 483.10G1 and Section 483.10G16. For further explanation of safety concerns, refer to Section 483.25D, F689. For information on smoking policies, refer to Section 483.90I5, F926. Procedures Section 483.10, F13 and 8. During interviews with residents or their family and / or representative S, determine if they are given the opportunity to choose and whether facility staff accommodate his or her preferences. 4. Activities that interest them. Their sleep cycles, their bathing times and methods, their eating schedule, their healthcare options, and any other area significant to the resident. Interview facility staff about what the resident's goals, preferences, and choices are and the location of that information. Interview facility staff to determine how they sought information from the resident's family and / or representative S regarding a resident's preferences and choices. For residents who are unable to express their choices, additionally, the resident's preferences should be accommodated by facility staff and reflected through adjustments in the care plan. Ask the social worker or other appropriate staff how they help residents pursue activities outside the facility. Examples of noncompliance may include, but are not limited to, residents are not given the opportunity to choose activities that interest them. Facility staff have a set schedule for waking residents or putting residents in bed without consideration of resident preference. Facility staff have a practice of showering all residents when a bath is available and preferred by a resident. Residents are not afforded the opportunity to choose among offered healthcare options. Restriction of any one of these rights are placed on any resident, including a justice involved resident solely based on their status as a justice-involved individual, without consideration of how exercising their rights affected the rights of other residents. Potential tags for additional consideration. If other concerns are identified regarding justice-involved residents, see Section 483.10A. F550, Resident Rights for further guidance. For issues regarding a resident's accommodation of needs, see Section 483.10E3, F558. For issues related to resident visitation, see Section 483.10 F4 Roman 2V, F563. If it is determined a resident's preferences is not honored due to possible concerns with insufficient numbers of staff or staff competencies, see Section 483.3, 5A, F725, sufficient. Nursing staff. Tag F562. Section 483.10, F4I, the facility must provide immediate access to any resident by A. Any representative of the Secretary. B. Any representative of the state. C. Any representative of the Office of the State Long-Term Care Ombudsman. Established under Section 712 of the Older Americans Act of 1965, as amended 2016. 42 U.S.C. 3001 et sec. D. The resident's individual physician. E. Any representative of the protection and advocacy systems, as designated by the state and as established under the Developmental Disabilities Assistance and Bill of Rights Act of 2042 U.S.C. 15001 et sec. F. Any representative of the agency responsible for the protection and advocacy system for individuals with mental disorder established under the Protection and Advocacy for Mentally Ill Individuals Act of 2042 U.S.C. 10801 et seq. And G. The Resident Representative. Guidance Section 483.10 F4I. The facility must provide immediate access to the resident by the resident's physician, representative, and various state and federal officials and organizations as outlined in the regulation, which would include state and federal surveyors. Surveyors are considered representatives of the secretary or the state. Facility staff cannot prohibit surveyors from talking to residents, family members, and resident representatives. Note, if facility staff attempt to interfere with the survey process and restrict a surveyor's ability to gather necessary information to determine compliance with requirements, surveyors should consult with the CMS Regional Office. Tag F563. Section 483.10 F4. The resident has a right to receive visitors of his or her choosing at the time of his or her choosing, subject to the resident's right to deny visitation when applicable and in a manner that does not impose on the rights of another resident. Roman 2. The facility must provide immediate access to a resident by immediate family and other relatives of the resident, subject to the resident's right to deny or withdraw consent at any time. Roman 3. The facility must provide immediate access to a resident by others who are visiting, with the consent of the resident, subject to reasonable clinical and safety restrictions, and the resident's right to deny or withdraw consent at any time. Roman 4. The facility must provide reasonable access to a resident by any entity or individual that provides health, social, legal, or other services to the resident, subject to the resident's right to deny or withdraw consent at any time, and v. The facility must have written policies and procedures regarding the visitation rights of residents, including those setting forth any clinically necessary or reasonable restriction or limitation or safety restriction or limitation, when such limitations may apply consistent with the requirements of this subpart, that the facility may need to place on such rights, and the reasons for the clinical or safety restriction or limitation. Guidance Section 483.10 F4 Roman 2v. Reasonable clinical and safety restrictions include a facility's policies, procedures, or practices that protect the health and security of all residents and staff. These may include, but are not be limited to, restrictions placed to prevent community-associated infection or communicable disease, transmission to one or more residents, a resident's risk factors for infection e.g., immunocompromised condition or current health state e.g., end-of-life care should be considered when restricting visitors. In general, visitors with signs and symptoms of a transmissible infection e.g., a visitor is febrile and exhibiting signs and symptoms of an influenza-like illness should defer visitation until he or she is no longer potentially infectious e.g., 24 hours after resolution of fever without antipyretic medication or according to CDC guidelines and / or local health department recommendations. Keeping the facility locked or secured at night with a system in place for allowing visitors approved by the resident, denying access or providing limited and supervised access to an individual if that individual is suspected of abusing, exploiting, or coercing a resident until an investigation into the allegation has been completed or has been found to be abusing, exploiting, or coercing a resident, denying access to individuals who have been found to have been committing criminal acts such as theft, denying access to individuals who are inebriated or disruptive, or denying access or providing supervised visitation to individuals who have a history of bringing illegal substances into the facility, which places residents' health and safety at risk. Visitation considerations during a communicable disease outbreak. Facilities may need to modify their visitation practices when there are infectious outbreaks or pandemics to align with current CMS guidance and CDC guidelines that enables maximum visitation, such as by offering options for outdoor or virtual visitation or indoor designated visitation areas, providing adequate signage with instructions for infection prevention, i.e. hand hygiene, cough etiquette, etc., ensuring access to hand hygiene supplies, taking other actions that would allow visitation to continue to occur safely in spite of the presence of a contagious infection, contacting their local health authorities for guidance or direction on how to structure their visitation to reduce the risk of communicable disease transmission during an outbreak. During an infectious disease outbreak, while not recommended, residents who are on transmission-based precautions (TBP) can still receive visitors. In these cases, before visiting residents who are on TBP, visitors should be made aware of the potential risk of visiting and precautions necessary in order to visit the resident. Visitors should adhere to principles of infection prevention. For purposes of this regulation, immediate family is not restricted to individuals united by blood, adoptive or marital ties, or a state's common law equivalent. It is important to understand that there are many types of families, each of which being equally viable as a supportive, caring unit. For example, it might also include a foster family, where one or more adult serves as a temporary guardian for one or more children to whom they may, or may not be biologically related. Residents have the right to define their family. During the admissions process, facility staff should discuss this issue with the resident. If the resident is unable to express or communicate whom they identify as family, facility staff should discuss this with the resident's representative. Residents' family members are not subject to visiting hour limitations or other restrictions not imposed by the resident, with the exception of reasonable clinical and safety restrictions, consistent with Section 483.10 F4V, placed by the facility based on recommendations of CMS, CDC, or the local health department. With the consent of the resident, facilities must provide 24-hour access to other non-relative visitors, subject to reasonable clinical and safety restrictions. Visitation should be person-centered. Consider the resident's physical, mental, and psychosocial well-being and support their quality of life. If these familial visitation rights infringe upon the rights of other residents, facility staff must find a location other than a resident's room for visits. For example, if a resident's family visits in the late evening when the resident's roommate is asleep, then the visit should take place somewhere other than their shared room so that the roommate is not disturbed. Individuals who provide health, social, legal, or other services to the resident have the right of reasonable access to the resident. Facility staff must provide space and privacy for such visits. Visitation and illegal substance use. It is important for facility staff to have knowledge of signs, symptoms, and triggers of possible illegal substance use, such as changes in resident behavior, particularly after interaction with visitors or leaves of absence, increased unexplained drowsiness, lack of coordination, slurred speech, mood changes, and / or loss of consciousness, etc. Following such occurrences, this may include asking residents who appear to have used an illegal substance, e.g., cocaine, hallucinogens, heroin, whether or not they possess or have used an illegal substance. If the facility determines illegal substances have been brought into the facility by a visitor, the facility should not act as an arm of law enforcement. Rather, in accordance with state laws, these cases may warrant a referral to local law enforcement to protect the health and safety of residents. Facilities may need to provide additional monitoring and supervision. Additionally, facility staff should not conduct searches of a resident or their personal belongings unless the resident or resident representative agrees to a voluntary search and understands the reason for the search, for concerns related to the identification of risk and the provision of supervision to prevent accidental overdose. Investigate potential noncompliance at F689, Section 483.25d. Accidents. For concerns related to the behavioral health services that are provided, investigate potential non-compliance at F740, Section 483.40, Behavioral Health Services. Procedures, Section 483.10, F4 Roman 2v. Through interviews with residents, their representative, family members, visitors, and others as permitted under this requirement, determine if they know that they are able to visit 24 hours a day, subject to a resident's choice and reasonable restrictions as defined above. Review the facility's written visitation policy and procedures to determine whether they support the resident's right to visitors and whether they explain those situations where visitors may be restricted due to clinical or safety concerns. If a concern is identified, interview facility staff to determine how they ensure 24-hour or immediate access as permitted under these requirements. Examples of noncompliance may include, but are not limited to: facility staff restrict visitors according to the facility's convenience. Facility staff restrict the rights of a resident to receive visitors, even though this would not affect the rights of other residents. Facility staff restrict visitors based on expressed wishes of an individual who is a health care power of attorney who does not have the authority to restrict visitation. A posting or inclusion in the resident handbook or other information provided by the facility of visiting hours not in compliance with this regulation. Tag F564. Section 483.10, F4 Roman 6. A facility must meet the following requirements. A. Inform each resident or resident representative, where appropriate, of his or her visitation rights and related facility policy and procedures, including any clinical or safety restriction or limitation on such rights, consistent with the requirements of this subpart, the reasons for the restriction or limitation, and to whom the restrictions apply, when he or she is informed of his or her other rights under this section. B. Inform each resident of the right, subject to his or her consent, to receive the visitors whom he or she designates, including, but not limited to, a spouse including a same-sex spouse, a domestic partner including a same-sex domestic partner, another family member, or a friend, and his or her right to withdraw or deny such consent at any time. C. Not restrict, limit, or otherwise deny visitation privileges on the basis of race, color, national origin, religion, sex, gender identity, sexual orientation, or disability. D. Ensure that all visitors enjoy full and equal visitation privileges consistent with resident preferences. Guidance Section 483.10, F4 Roman 6. All residents have the right to visitors in accordance to their preferences. The facility policy for restricting or limiting visitors must be communicated to the resident. If limitations are placed on a resident's visitation rights, the clinical or safety reasons for the limitations, and the specific individuals the restriction applies to must be communicated to the resident or resident representative in a manner he or she understands. Facility staff may not place limitations on a resident based solely on their status as a justice, involved resident, or as a part of restrictive law enforcement requirements, such as conditions of probation or parole. See Section 483.10a, F550, Resident Rights for Guidance on Justice Involved. Residents. Procedures Section 483.10 F4 Roman 6. Through interviews with residents and or their representatives, determine how they were informed of their visitation rights and related policies and procedures, including their right to consent to receive or deny visitors he or she designates, any clinical or safety restriction or limitation on such rights imposed by the facility. Determine if the facility has ensured visitation rights consistent with resident preference. Examples of noncompliance may include, but are not limited to, prohibiting a resident from having visits from his or her spouse or domestic partner, including a same-sex spouse or partner. Facility staff did not inform a resident, the family, and or resident representative of their visitation rights, including any restrictions or limitations of these rights that may be imposed by the facility or the resident, the family, and or resident representative. Facility staff denied, limited, or restricted a resident's visitation privileges contrary to their choices, even though there were no clinical or safety reasons for doing so. Tag F565. Section 483.10 F5. The resident has a right to organize and participate in resident groups in the facility. The facility must provide a resident or family group, if one exists, with private space, and take reasonable steps, with the approval of the group, to make residents and family members aware of upcoming meetings in a timely manner. Roman 2 staff, visitors, or other guests may attend resident group or family group meetings only at the respective group's invitation. Roman 3. The facility must provide a designated staff person who is approved by the resident or family group and the facility and who is responsible for providing assistance and responding to written requests that result from group meetings. Roman 4. The facility must consider the views of a resident or family group and act promptly upon the grievances and recommendations of such groups concerning issues of resident care and life in the facility. The facility must be able to demonstrate their response and rationale for such response. This should not be construed to mean that the facility must implement as recommended every request of the resident or family group. Section 483.10 F6. The resident has a right to participate in family groups. Section 483.10 F7. The resident has a right to have family member S or other resident representative S meet in the facility with the families or resident representative S of other residents in the facility. Definitions, Section 483.10 F57. A resident or family group is defined as a group of residents or residents' family members that meets regularly to discuss and offer suggestions about facility policies and procedures affecting residents' care, treatment, and quality of life, support each other, plan resident and family activities, participate in educational activities, or for any other purpose. Guidance Section 483.10 F57. This requirement does not require that residents organize a resident or family group. However, whenever residents or their families wish to organize, they must be able to do so without interference. Additionally, they must be provided space, privacy for meetings, and staff support. The designated staff person, responsible for assistance and liaison between the group and the facility's administration, and any other staff members, may attend the meeting only if invited by The resident or family group. The resident or family group may meet without staff present. The groups should determine how frequently they meet. Facility staff are required to consider resident and family group views and act upon grievances and recommendations. Facility staff must consider these recommendations and attempt to accommodate them to the extent practicable. This may include developing or changing policies affecting resident care and life. Facility staff should discuss its decisions with the resident and/or family group and document in writing its response and rationale as required under 42 CFR. Section 483.10J, F585, Grievances. Procedures, Section 483.10 F57. During the entrance interview, determine if there is a resident or family group, who the resident or family representative is for each of these groups, and who the designated staff person is for assisting and working with each of these groups. If residents or their families attempted to organize a group and were unsuccessful, why? Through interviews with the representatives for the resident and family groups and staff designated for assisting and working with these groups, determine: are groups able to meet without staff present unless desired? If a resident wants a family member present during a resident group meeting, how is this handled? Facility staff should not require said family member to leave the group meeting without the permission of the group. How views, grievances, or recommendations from these groups are considered, addressed, and acted upon, and how facility staff provide responses, actions, and rationale to the groups. Examples of noncompliance may include, but are not limited to: facility staff impede or prevent residents or family members' ability to meet or organize a resident or family group. Resident and/or families were not always informed in advance of upcoming meetings. Facility staff impede with meetings and/or operations of family or resident council by mandating that they have a staff person in the room during meetings or assigning a staff person to liaise with the council that is not agreeable to the council. Private meeting space for these groups is not provided. The views, grievances, or recommendations from these groups have not been considered or acted upon by facility staff. Facility staff does not provide these groups with responses, actions, and rationale taken regarding their concerns. Facility staff are not able to demonstrate their response and rationale to grievances. Facility staff prevent family members or representatives from meeting with those of another resident. Potential tags for additional investigation. For concerns regarding the handling of individual grievances, refer to Section 483.10J, F585. Grievances. Tag F566. Section 483.10 F9. The resident has a right to choose or refuse to perform services for the facility, and the facility must not require a resident to perform services for the facility. The resident may perform services for the facility if he or she chooses when the facility has documented the resident's need or desire for work in the plan of care. Roman 2, the plan specifies the nature of the services performed and whether the services are voluntary or paid. Roman 3, compensation for paid services is at or above prevailing rates. And Roman 4, the resident agrees to the work arrangement described in the plan of care. Definitions, Section 483.10 F9. Prevailing rate is the wage paid to the majority of workers in the community surrounding the facility for the same type, quality, and quantity of work requiring comparable skills. Guidance, Section 483.10 F9. All work or services provided by a resident, whether voluntary or paid, must be part of his or her care plan. Any work assignment must be agreed to and negotiated by the resident or the resident's representative. The resident also has the right to refuse to participate in these services or assignments at any time. A resident's request to work or perform services should be discussed by the interdisciplinary team and be clinically and psychologically appropriate for the resident. Procedures Section 483.10 F9. Through interviews with residents, resident representatives, and staff, determine if residents were given a choice as to whether or not they were willing to perform services. During observations, note whether residents are engaged in performing these services, such as housekeeping, laundry, meal setup, etc. Review the resident's care plan to ensure it includes the nature of the services to be provided, including the resident's desire to do so, and the objectives for this arrangement, and whether they are provided voluntarily or paid. Examples of noncompliance may include, but are not limited to, the resident or his or her representative did not agree to the work arrangements. The resident's care plan does not specify the nature of the services provided by the resident or whether or not they are voluntary or paid, or compensation for paid services is not at or above prevailing rates. Tag F567. Section 483.10 F10. The resident has a right to manage his or her financial affairs. This includes the right to know, in advance, what charges a facility may impose against a resident's personal funds. The facility must not require residents to deposit their personal funds with the facility. If a resident chooses to deposit personal funds with the facility, upon written authorization of a resident, the facility must act as a fiduciary of the resident's funds and hold, safeguard, manage, and account for the personal funds of the resident deposited with the facility, as specified in this section. Roman 2, Deposit of funds. In general, except as set out in paragraph FL0 Roman 2b of this section, the facility must deposit any resident's personal funds in excess of $100 in an interest-bearing account or accounts that is separate from any of the facility's operating accounts, and that credits all interest earned on residents' funds to that account. In pooled accounts, there must be a separate accounting for each resident's share. The facility must maintain a resident's personal funds that do not exceed $100 in a non-interest-bearing account, interest-bearing account, or petty cash fund. B. Residents whose care is funded by Medicaid. The facility must deposit the resident's personal funds in excess of $50 in an interest-bearing account or accounts that is separate from any of the facility's operating accounts, and that credits all interest earned on residents' funds to that account. In pooled accounts, there must be a separate accounting for each resident's share. The facility must maintain personal funds that do not exceed $50 in a non-interest bearing account, interest-bearing account, or petty cash fund. Intent Section 483.10 F10I Roman 2. To assure residents who have authorized the facility in writing to manage any personal funds have ready and reasonable access to those funds. Definitions Section 483.10 F10I Roman 2. Hold, safeguard, manage, and account for means that the facility must act as fiduciary of the resident's funds and report at least quarterly on the status of these funds in a clear and understandable manner. Managing the resident's financial affairs includes money that an individual gives to the facility for the sake of providing a resident with a non-covered service. In these instances, the facility will provide a receipt to the gift giver and retain a copy. Interest-bearing means a rate of return equal to or above the rate at local banking institutions. In the area, if pooled accounts are used, interest must be prorated per individual on the basis of actual earnings or end-of-quarter balance. Guidance Section 483.1, 0F10I Roman 2. If a resident or resident representative chooses to have the facility manage the resident's funds, facility staff may not refuse to handle these funds. Facility staff are not expected to be familiar with resident assets not on deposit with the facility. Placement of residents' personal funds of less than $100.00 $50.00 for Medicaid residents in an interest-bearing account is permitted. Thus, a facility may place the total amount of a resident's funds, including funds of $100.00 $50.00 for Medicaid residents or less, into an interest-bearing account. The law and regulations are intended to assure that residents have access to $100.00 $50.00 for Medicaid residents in cash within a reasonable period of time. When requested, requests for less than $100.00 $50.00 for Medicaid residents should be honored within the same day. Requests for $100.00 $50.00 for Medicaid residents or more should be honored within 3 banking days. Although the facility need not maintain $100.00 $50.00 for Medicaid residents per resident on its premises, it is expected to maintain amounts of petty cash on hand that may be required by residents. If pooled accounts are used, interest must be prorated per individual on the basis of actual earnings or end-of-quarter balance. Residents should have access to petty cash on an ongoing basis and be able to arrange for access to larger funds. Although the facility need not maintain $100.00 $50.00 for Medicaid residents per resident on its premises, it is expected to maintain petty cash on hand to honor resident requests. Resident requests for access to their funds should be honored by facility staff as soon as possible, but no later than the same day for amounts less than $100.00 $50.00 for Medicaid residents. 3 banking days for amounts of $100.00 $50.00 for Medicaid residents or more. Residents may make requests that the facility temporarily place their funds in a safe place. Without authorizing the facility to manage those funds, the facility must have a system to document the date, time, amount, and who the funds were received from or dispersed to. The facility must have systems in place to safeguard against any misappropriation of a resident's funds. Note, banks may charge the resident a fee for handling their funds and pass this fee on to the residentess. Facilities may not charge residents for managing residents' funds because the services are covered by Medicare or Medicaid or by the facility's per diem rate. Monies due residents should be credited to their respective bank accounts within a few business days. Procedures Section 483.1, 0F10I Roman 2. Interview residents and / or their representatives to determine if they have experienced problems with the facility's management of their personal funds. Residents and / or their representatives to determine if they have ready access to their personal funds. Facility staff to determine how they manage, account for, and safeguard a resident's funds. To assure facility staff are not using oral requests by residents as a way to avoid obtaining written authorization to hold, manage, safeguard, and account for residents' funds. Ensure facility staff provide the resident a receipt for these funds and retains a copy for its records. Review the facility records for residents selected for a comprehensive review who have authorized the facility to handle their personal funds. Are residents' funds over $100.00 $50.00 for Medicaid residents or at the facilities? Option: all resident funds in an interest-bearing account. What procedure was followed when residents requested their funds? How long does it take for residents to receive A. Petty cash allotments, B. funds needing to be withdrawn from bank accounts? Were limits placed on amounts that could be withdrawn? If yes, was the reason based on resident care needs or facility convenience? Are funds records treated with privacy as required at F583? Examples of noncompliance may include, but are not limited to, requiring residents to deposit their personal funds with the facility, not crediting all interest earned on a resident's funds to the resident's account, dispersing the resident's funds to anyone without the resident's or the resident representative's permission, not providing a resident access to their funds as soon as possible. Tag F568. Section 483.1, 0F10 Roman 3, Accounting and Records. A. The facility must establish and maintain a system that assures a full and complete and separate accounting, according to generally accepted accounting principles, of each resident's personal funds entrusted to the facility on the resident's behalf. B. The system must preclude any commingling of resident funds with facility funds or with the funds of any person other than another resident. C. The individual financial record must be available to the resident through quarterly statements and upon request. Guidance Section 483.1, 0F10 Roman 3. Generally accepted accounting principles means that facility staff employ proper bookkeeping techniques by which it can determine, upon request, the amount of individual resident funds and, in the case of an interest-bearing account, how much interest these funds have earned for each resident, as last reported by the banking institution to the facility. Proper bookkeeping techniques include an individual record established for each resident on which only those transactions involving his or her personal funds are recorded and maintained. The record should have information on when transactions occurred, what they were, and maintain the ongoing balance for every resident. For each transaction, the resident should be given a receipt, and the facility retains a copy. Quarterly statements must be provided in writing to the resident or the resident's representative within 30 days after the end of the quarter and upon request. Procedures Section 483.1, 0F10 Roman 3. Through interviews with the resident or his or her representative, determine how they receive statements regarding the status of their funds and accounts. If concerns arise based on these interviews, review the facility's records to determine if generally accepted accounting principles are followed. Records must show separate accounting for each resident, including the ongoing balance of each account, as well as the date and amount of any transaction. Additionally, the facility's records must include a copy of all account transactions. Examples of noncompliance may include, but are not limited to, evidence that the facility does not maintain a system that assures a complete and separate accounting of each resident's personal funds. Commingles resident funds with facility funds, for example, commingling an activity fund, volunteer fund, and resident personal funds into one account. Commingles resident funds with those of someone other than a resident, such as a facility staff member managing a resident's personal funds through the facility staff members. Personal bank account does not provide a financial record or quarterly statement to the resident or his or her representative. Tag F569. Section 483.1, 0F10 Roman 4, Notice of certain balances. The facility must notify each resident that receives Medicaid benefits. A. When the amount in the resident's account reaches $200 less than the SSI resource limit for one person, specified in Section 1611A3B of the Act, and b. that, if the amount in the account, in addition to the value of the resident's other non-exempt resources, reaches the SSI resource limit for one person, the resident may lose eligibility for Medicaid or SSI. Section 483.1, 0F10V conveyance upon discharge, eviction, or death. Upon the discharge, eviction, or death of a resident with a personal fund deposited with the facility must convey within 30 days the resident's funds and a final accounting of those funds to the resident, or in the case of death, the individual or probate jurisdiction administering the resident's estate in accordance with state law. Procedures Section 483.1, 0F10 Roman 4V. As part of closed record review, determine if within 30 days of discharge, eviction, or death, facility staff conveyed the resident's personal funds and a final accounting to the individual or probate jurisdiction administering the individual's estate as provided by state law. Through interviews with the resident or his or her representative, determine if they lost their SSI or Medicaid eligibility and whether this loss was a result of the facility's staff failure to notify them as required in this regulation. Tag F550. Section 483.1, 0F10 Roman 6, assurance of financial security. The facility must purchase a surety bond or otherwise provide assurance satisfactory to the Secretary to assure the security of all personal funds of residents deposited with the facility. Definition Section 483.1, 0F10 Roman 6. Surety bond is an agreement between the principal, the facility, the surety, the insurance company, and the obligee depending on state law, either the resident or the state acting on behalf of the resident, wherein the facility and the insurance company agree to compensate the resident or the state on behalf of the resident for any loss of residents' funds that the facility holds, safeguards, manages, and accounts for. Guidance Section 483.1, 0F10 Roman 6. The purpose of the surety bond is to guarantee that the facility will pay the resident or the state on behalf of the resident for losses occurring from any failure by the facility to hold, safeguard, manage, or account for the resident's funds, for example, losses occurring as a result of acts or errors of negligence, incompetence, or dishonesty. The surety bond protects the resident or the state, not the facility, from loss. It differs from a fidelity bond, which covers no acts or errors of negligence, incompetence, or dishonesty. The surety bond is the commitment of the facility, an objective manner that the facility will hold, safeguard, manage, and account for the personal funds residents have deposited with the facility. The facility assumes the responsibility to compensate the resident or the state for the amount of the loss up to the entire amount of the surety bond. The surety bond is not limited to personal needs allowance funds. Any resident funds that are entrusted to the facility for a resident must be covered by the surety bond, including refundable deposit fees. The facility cannot be named as a beneficiary. Self-insurance is not an acceptable alternative to a surety bond. Likewise, funds deposited in bank accounts protected by the Federal Deposit Insurance Corporation or similar entity also are not acceptable alternatives. Procedures Section 483.1, 0F10 Roman 6. Through interviews with residents or their representative, determine if they were compensated for losses occurring from any failure by facility staff to hold, safeguard, manage, or account for the resident's funds, for example, losses occurring as a result of acts or errors of negligence, incompetence, or dishonesty. If concerns arise based on these interviews, review the facilities records to determine whether these concerns are substantiated. If the state survey agency determines that individual circumstances associated with a facility's surety bond or its alternative are such that the survey agency cannot determine whether or not the facility is in compliance with these requirements, then it would be appropriate to make the referral to the state's fiscal department. If a corporation has a surety bond that covers all of its facilities, there should be a separate review of the corporation's surety bond by the appropriate state agency, such as the state's fiscal department, to ensure that all the residents in the corporation's facilities within that state are covered against any losses due to acts or errors by the corporation or any of its facilities. The focus of the review should be to ensure that if the corporation were to go bankrupt or otherwise cease to operate, the funds of the residents in the corporation's facilities would be protected. Tag F571. Section 483.1. 0F11. The facility must not impose a charge against the personal funds of a resident for any item or service for which payment is made under Medicaid or Medicare, except for applicable deductible and coinsurance amounts. The facility may charge the resident for requested services that are more expensive than or in excess of covered services in accordance with Section 489.32 of this chapter. This does not affect the prohibition on facility charges for items and services for which Medicaid has paid. See Section 447.15 of this chapter, which limits participation in the Medicaid program to providers who accept, as payment in full, Medicaid payment plus any deductible, coinsurance, or co-payment required by the plan to be paid by the individual. Services included in Medicare or Medicaid payment during the course of a covered Medicare or Medicaid stay. Facilities must not charge a resident for the following categories of items and services: A. Nursing services, as required at Section 483.35. B. Food and nutrition services, as required at Section 483.60. C. An activities program, as required at Section 483.24C. D. Room/bed maintenance services. E. Routine personal hygiene items and services, as required to meet the needs of residents, including but not limited to hair hygiene supplies, comb, brush, bath soap, disinfecting soaps, or specialized cleansing agents when indicated to treat special skin problems or to fight infection, razor, shaving cream, toothbrush, toothpaste, denture adhesive, denture cleaner, dental floss, moisturizing lotion, tissues, cotton balls, cotton swabs, deodorant, incontinence care and supplies, sanitary napkins and related supplies, towels, washcloths, hospital gowns, over-the-counter drugs, hair and nail hygiene services, bathing assistance, and basic personal laundry. F. Medically related social services, as required at Section 483.40D. G. Hospice services, elected by the resident and paid for under the Medicare hospice benefit or paid for by Medicaid under a state plan. Roman II. Items and services that may be charged to residents' funds. Paragraphs F11 Roman IIA through L of this section are general categories and examples of items and services that the facility may charge to residents' funds if they are requested by a resident, if they are not required to achieve the goals stated in the resident's care plan, if the facility informs the resident that there will be a charge, and if payment is not made by Medicare or Medicaid. A. Telephone, including a cellular phone. B. Television/radio, personal computer, or other electronic device for personal use. C. Personal comfort items, including smoking materials, notions and novelties, and confections. D. Cosmetic and grooming items and services in excess of those for which payment is made under Medicaid or Medicare. E. Personal clothing. F. Personal reading matter. F. Gifts purchased on behalf of a resident. H. Flowers and plants. I. Cost to participate in social events and entertainment outside the scope of the activities program provided under Section 483.24c. J. Non-covered special care services, such as privately hired nurses or aides. K. Private room, except when therapeutically required, for example, isolation for infection control. L. Except as provided in E11 Roman 2L1 and 2 of this section, specially prepared. Or alternative food, requested instead of the food and meals, generally prepared by the facility, as required by Section 483.60. 1. The facility may not charge for special foods and meals, including medically prescribed dietary supplements ordered by the resident's physician, physician assistant, nurse practitioner, or clinical nurse specialist, as these are included per Section 483.60. 2. In accordance with Section 483.60C through F, when preparing foods and meals, a facility must take into consideration residents' needs and preferences and the overall cultural and religious makeup of the facility's population. Roman 3. Request for items and services. A. The facility can only charge a resident for any non-covered item or service if such item or service is specifically requested by the resident. B. The facility must not require a resident to request any item or service as a condition of admission or continued stay. C. The facility must inform, orally and in writing, the resident requesting an item or service for which a charge will be made that there will be a charge for the item or service and what the charge will be. Guidance Section 483.10 F11. Residents must not be charged for universal items such as computers, telephones, television, services or other electronic devices, books, magazines, or newspaper subscriptions intended for use by all residents. Procedures Section 483.10 F11. During interviews with residents or their representatives, determine how and when they were notified by facility staff regarding the items and services that may not be covered during their stay at the facility, whether or not they may have been charged for items or services they believed were covered by the facility or their insurer. If concerns are raised, review a resident's billing statements to determine if they were charged for covered items or services. If charges found on these statements indicate that residents may have paid for covered items or services, determine if these items or services are over and above what is paid by Medicare or Medicaid. How and when they were informed of any items or services that would be charged to them before these items or services are provided. Key elements of noncompliance Section 483.10 F11. To cite deficient practice at F571, the surveyor's investigation will generally show that the facility failed to do one or more of the following: made a charge against the resident's personal funds for any item or service covered under Medicare or Medicaid, except for applicable deductible or coinsurance amounts, or charged a resident for an item or services not required to achieve the goal stated in the resident's care plan without notifying the resident of the charge, or charged a resident for any item or service not covered under Medicare or Medicaid, but did not inform the resident orally and in writing of the charge, or charged a resident for specially prepared or alternative food when ordered by a physician or non-physician practitioner, or prepared in consideration of the resident need, or prepared in consideration of the overall cultural and religious makeup of the resident population, or charged a resident for any non-covered item or service when not requested by the resident, or made the resident request any item or services as a condition of admission or continued stay. Tag F572. Section 483.1, 0G Information and Communication. Section 483.1, 0G1, the resident has the right to be informed of his or her rights and of all rules and regulations governing resident conduct and responsibilities during his or her stay in the facility. Section 483.1, 0G16, the facility must provide a notice of rights and services to the resident prior to or upon admission and during the resident's stay. The facility must inform the resident both orally and in writing in a language that the resident understands of his or her rights and all rules and regulations governing resident conduct and responsibilities during the stay in the facility. Roman 2, the facility must also provide the resident with the state-developed notice of Medicaid rights and obligations, if any. Roman 3, receipt of such information and any amendments to it must be acknowledged in writing. Intent Section 483.10 G1, 16. This requirement is intended to assure that each resident knows his or her rights and responsibilities, and that facility staff communicates this information prior to or upon admission, as appropriate during the resident's stay and when the facility's rules change. Definitions Section 483.10 G1, 16. All rules and regulations relates to state and federal requirements and facility policies, both orally and in writing, means if a resident can read and understand written materials. Without assistance, an oral summary along with the written document is acceptable. In a language that the resident understands means verbally, in writing, and in a language that is clear and understandable to the resident and / or his or her representative. Guidance Section 483.10 G1, 16. Anytime state or federal laws or regulations relating to resident rights or facility policies change during the resident's stay in the facility, she must promptly be informed of these changes in a manner that is clear to the resident. A resident cannot be expected to abide by rules she has never been told about, whatever rules or policies the facility has formalized, and by which it expects residents to abide, should be included in the resident's statement of rights and responsibilities. If a resident or his or her representative's understanding of English or the predominant language of the facility is inadequate for their comprehension, a means to communicate information in a language or format familiar to the resident or his or her representative must be used. The facility must have written translations, including Braille, and make the services of an interpreter available as needed for those residents who communicate in American Sign Language ASL. Facility staff are expected to provide an interpreter. Large print text of the facility's statement of resident rights and responsibilities may also be made available. Procedures Section 483.10 G116. During interviews, determine when and how residents or their representatives are informed of their rights, services, facility policies and procedures, and resident responsibilities. If this information was provided in a language and format they understood, and if facility staff provide ongoing communication to residents about their rights, e.g., through resident and family groups, presentations from representatives of the Office of the State Long-Term Care Ombudsman, posting of information, etc. Tag F573. Section 483.10 G2. The resident has the right to access personal and medical records pertaining to him or herself. The facility must provide the resident with access to personal and medical records pertaining to him or herself upon an oral or written request in the form and format requested by the individual, if it is readily producible in such form and format, including in an electronic form or format when such records are maintained electronically, or, if not, in a readable hard copy form or such other form and format as agreed to by the facility and the individual within 24 hours excluding weekends and holidays, and Roman II, the facility must allow the resident to obtain a copy of the records or any portions thereof, including in an electronic form or format when such records are maintained electronically upon request, and 2 working days advance notice to the facility. The facility may impose a reasonable, cost-based fee on the provision of copies, provided that the fee includes only the cost of A. Labor for copying the records requested by the individual, whether in paper, electronic form, B. Supplies for creating the paper copy, or electronic media if the individual requests that the electronic copy be provided on portable media, and C. Postage, when the individual has requested the copy be mailed. Section 483.10 G3. With the exception of information described in paragraphs G2 and G11 of this section, the facility must ensure that information is provided to each resident in a form and manner the resident can access and understand, including in an alternative format or in a language that the resident can understand, summaries that translate. Information described in paragraph G2 of this section may be made available to the patient at their request and expense in accordance with applicable law. Definitions, section 483.10 G23. Records includes all records, in addition to clinical records pertaining to the resident, such as trust fund ledgers pertinent to the resident, and contracts between the resident and the facility. Guidance section 483.10 G23. An oral request is sufficient to produce the resident's personal and medical record for review. The facility may charge a reasonable, cost-based fee for providing a copy of the requested records, whether in paper or electronic form. This may only include the cost of labor for copying the records, supplies for creating the paper copy or electronic media, and postage if applicable. Additional fees for locating the records or typing forms/envelopes may not be assessed. Key elements of noncompliance section 483.10 G23. To cite deficient practice at F573, the surveyor's investigation will generally show that the facility failed to do one or more of the following: support the resident's right to access his or her own personal and medical records, or provide the resident access to his or her personal and medical records within 24 hours, excluding weekends and holidays of a written request, or allow the resident to purchase a copy of his or her personal and medical records upon request and with 2 working days advance notice, or charge a reasonable, cost-based fee, including only the cost of labor, supplies, and postage involved in providing or sending the personal and medical records requested, or ensure the information is provided in a form the resident can access and understand, or in a form and format agreed upon by the facility and the resident. Tag F574. Section 483.10 G4. The resident has the right to receive notices orally, meaning spoken and in writing, including Braille in a format and a language he or she understands, including I required notices as specified in this section. The facility must furnish to each resident a written description of legal rights, which includes a description of the manner of protecting personal funds, under paragraph F10 of this section. B. A description of the requirements and procedures for establishing eligibility for Medicaid, including the right to request an assessment of resources under Section 1920, 4C of the Social Security Act. See a list of names, addresses, mailing and email, and telephone numbers of all pertinent state regulatory and informational agencies, resident advocacy groups, such as the State Survey Agency, the State Licensure Office, the State Long-Term Care Ombudsman Program, the Protection and Advocacy Agency, Adult Protective Services, where state law provides for jurisdiction in long-term care. Facilities, the local contact agency for information about returning to the community and the Medicaid Fraud Control Unit, and D. A statement that the resident may file a complaint with the State Survey Agency concerning any suspected violation of state or federal nursing facility regulations, including but not limited to resident abuse, neglect, exploitation, misappropriation of resident property in the facility, non-compliance with the advance directives, requirements, and requests for information regarding returning to the community. Roman II, information and contact information for state and local advocacy organizations, including but not limited to the State Survey Agency, the State Long-Term Care Ombudsman Program, established under Section 712 of the Older Americans Act of 1965, as amended 2016 42 U.S.C. 3001 et seq., and the Protection and Advocacy System as designated by the state and as established under the Developmental Disabilities Assistance and Bill of Rights Act of 2042 U.S.C. 15001 et seq. Roman III, information regarding Medicare and Medicaid eligibility and coverage. Roman IV, contact information for the Aging and Disability Resource Center, established under Section 200, 2820b Roman III of the Older Americans Act, or other no wrong. DOOR Program. V. Contact information for the Medicaid Fraud Control Unit, and Roman VI, information and contact information for filing grievances or complaints concerning any suspected violation of state or federal nursing facility regulations, including but not limited to resident abuse, neglect, exploitation, misappropriation of resident property in the facility, non-compliance with the advance directives requirements, and requests for information regarding returning to the community. Definitions, Section 483.10 G4. Orally and in writing means if a resident can read and understand written materials without assistance, an oral summary along with the written document is acceptable. In a language he or she understands means verbally, in writing including Braille, and in a language that is clear and understandable to the resident or his or her representative. Guidance Section 483.10 G4. If a resident or his or her representative's understanding of English or the predominant language of the facility is inadequate for their comprehension, a means to communicate information in a language or format familiar to the resident or his or her representative must be used. The facility must have written translations, including Braille, and make the services of an interpreter available as needed. For those residents who communicate in American Sign Language ASL, the facility is expected to provide an interpreter. Large print texts of the facility's statement of resident rights and responsibilities should also be available. As part of determining Medicaid eligibility, at the time of admission, a married couple has the right to request and have the appropriate state agency assess the couple's resources. During interviews with residents, their representatives and facility staff determine when and how information regarding rights and services are communicated, and if this information was provided in a language and format the resident or representative understood. Key elements of Noncompliance Section 483.10 G4. To cite deficient practice at F574, the surveyor's investigation will generally show that the facility failed to do one or more of the following: support the resident's right to receive notices orally and in writing in a format he or she understands, or provide a written description of the resident's legal rights, including how a resident's personal funds are protected, or the requirements and procedures for establishing Medicaid eligibility, including the right to request an assessment of resources, or a list of names, mailing and email addresses, and telephone numbers of all pertinent state regulatory and informational agencies and advocacy groups, or informing the resident of their right to file a complaint with the state survey and certification agency, or provide information and contact information for state and local advocacy organizations, or the Aging and Disability Resource Center or other No Wrong Door program, or inform the resident of Medicare and Medicaid eligibility and coverage, or provide contact information for the Medicaid Fraud Control Unit, or provide information and contact information for filing grievances or complaints concerning any suspected violation of state or federal nursing facility regulations. Tag F575. Section 483.10 G5. The facility must post, in a form and manner accessible and understandable to residents, resident representatives, a list of names, addresses, mailing and email, and telephone numbers of all pertinent state agencies and advocacy groups, such as the State Survey Agency, the State Licensure Office, Adult Protective Services where state law provides for jurisdiction in long-term care facilities, the Office of the State Long-Term Care Ombudsman Program, the Protection and Advocacy Network, Home and Community Base Service Programs, and the Medicaid Fraud Control Unit, and Roman II, a statement that the resident may file a complaint with the State Survey Agency concerning any suspected violation of state or federal nursing facility regulation, including but not limited to resident abuse, neglect, exploitation, misappropriation of resident property in the facility, and noncompliance with the advance directives. Requirements 42 CFR Part 489, Subpart I, and requests for information regarding returning to the community. Tag F576. Section 483.10 G6. The resident has the right to have reasonable access to the use of a telephone, including TTY and TDD services, and a place in the facility where calls can be made without being overheard. This includes the right to retain and use a cellular phone at the resident's own expense. Section 483.10 G7. The facility must protect and facilitate that resident's right to communicate with individuals and entities within and external to the facility, including reasonable access to a telephone, including TTY and TDD services. Roman II, the Internet, to the extent available to the facility, and Roman III, stationery, postage, writing implements, and the ability to send mail. Section 483.10 G8. The resident has the right to send and receive mail, and to receive letters, packages, and other materials delivered to the facility for the resident through a means other than a postal service, including the right to privacy of such communications consistent with this section, and II. Access to stationery, postage, and writing implements at the resident's own expense. Section 483.1. 0G9. The resident has the right to have reasonable access to and privacy in their use of electronic communications, such as email and video communications, and for Internet research. If the access is available to the facility. II. At the resident's expense, if any additional expense is incurred by the facility to provide such access to the resident. III. Such use must comply with state and federal law. Definitions. Section 483.1. 0G69. Reasonable access means that telephones, computers, and other communication devices are easily accessible to residents and are adapted to accommodate residents' needs and abilities, such as hearing or vision loss. TTY Tele-TIP and TDD Telecommunications Device for the Deaf are acronyms used interchangeably to refer to any type of text-based telecommunications equipment used by a person who does not have enough functional hearing to understand speech, even with amplification. Guidance. Section 483.1. 0G69. Resident access to telephones in staff offices or at nurses' stations alone does not meet the provisions of this requirement. Examples of facility accommodations to provide reasonable access to the use of a telephone without being overheard include providing cordless telephones or having telephone jacks in residents' rooms. The facility is responsible for providing reasonable access to the Internet to the extent it is available on-site. Computers in public areas for general use must be located in a manner to protect resident privacy in email, communications, and Internet use. Potential tags for additional investigation. If concerns are identified regarding charges to the resident for access to Internet, telephone, etc., refer to Section 483.10 F11, F571. If concerns are identified to indicate a resident is being denied the right to private communication, refer to Section 483.10H, F583, Privacy and Confidentiality. Tag F577. Section 483.10 G10. The resident has the right to examine the results of the most recent survey of the facility conducted by federal or state surveyors and any plan of correction in effect with respect to the facility, and II. Receive information from agencies acting as client advocates and be afforded the opportunity to contact these agencies. Section 483.10 G11. The facility must post in a place readily accessible to residents and family members and legal representatives of residents the results of the most recent survey of the facility. II. Have reports with respect to any surveys, certifications, and complaint investigations made respecting the facility during the 3 preceding years, and any plan of correction in effect with respect to the facility, available for any individual to review upon request, and III. Post notice of the availability of such reports in areas of the facility that are prominent and accessible to the public. IV. The facility shall not make available identifying information about complainants or residents. Definitions. Section 483.10 G1011. Place readily accessible is a place such as a lobby or other area frequented by most residents, visitors, or other individuals, where individuals wishing to examine survey results do not have to ask to see them. Results of the most recent survey means the Statement of Deficiencies Form CMS 2567 and the Statement of Isolated Deficiencies generated by the most recent standard survey and any subsequent extended surveys and any deficiencies resulting from any subsequent complaint. Investigation S. Guidance Section 483.10 G1011. The survey results may not be altered by the facility unless authorized by the state agency. Tag F578. Section 483.10 C6. The right to request, refuse, and or discontinue treatment, to participate in or refuse to participate in experimental research, and to formulate an advance directive. Section 483.10 C8. Nothing in this paragraph should be construed as the right of the resident to receive the provision of medical treatment or medical services deemed medically unnecessary or inappropriate. Section 483.10 G12. The facility must comply with the requirements specified in 42 CFR Part 489, Subpart I. Advance Directives. I. These requirements include provisions to inform and provide written information to all adult residents concerning the right to accept or refuse medical or surgical treatment, and at the resident's option, formulate an advance directive. Roman II. This includes a written description of the facility's policies to implement advance directives and applicable state law. Roman III. Facilities are permitted to contract with other entities to furnish this information, but are still legally responsible for ensuring that the requirements of this section are met. Roman IV. If an adult individual is incapacitated at the time of admission and is unable to receive information or articulate whether or not he or she has executed an advance directive, the facility may give advance directive information to the individual's resident representative in accordance with state law. The facility is not relieved of its obligation to provide this information to the individual once he or she is able to receive such information. Follow-up procedures must be in place to provide the information to the individual directly at the appropriate time. Definitions Section 483.10 C6, C8, G12. Advance care planning is a process of communication between individuals and their healthcare agents to understand, reflect on, discuss, and plan for future healthcare decisions for a time when individuals are not able to make their own healthcare decisions. Advance directive is a written instruction, such as a living will or durable power of attorney, for healthcare recognized under state law, whether statutory or as recognized by the courts of the state, relating to the provision of health care when the individual is incapacitated. See Section 489.100. Physician orders for life-sustaining treatment or pulsed paradigm form is a form designed to improve patient care by creating a portable medical order form that records patients' treatment wishes so that emergency personnel know what treatments the patient wants in the event of a medical emergency, taking the patient's current medical condition into consideration. A pulsed paradigm form is not an advance directive. Experimental research refers to the development, testing, and use of a clinical treatment, such as an investigational drug or therapy that has not yet been approved by the FDA or medical community as effective and conforming to accepted medical practice. Healthcare decision-making refers to consent, refusal to consent, or withdrawal of consent to healthcare, treatment, service, or a procedure to maintain, diagnose, or treat a resident's physical or mental condition. Healthcare decision-making capacity refers to possessing the ability as defined by state law to make decisions regarding healthcare and related treatment choice. Guidance Section 483.10 C6, C8, and G12. The resident has the right to request treatment. However, facility staff are not required to provide Medical treatment or services, if the requested treatment or services are medically unnecessary or inappropriate. While the resident also has the right to refuse any treatment or services, the resident's refusal does not absolve facility staff from providing other care that allows him/her to attain or maintain his or her highest practicable physical, mental, and psychosocial well-being. For example, facility staff would still be expected to provide appropriate measures for pressure injury prevention, even if a resident has refused food and fluids and is nearing death. If a resident directly, or through an advance directive, declines treatment such as refuses artificial nutrition or Roman IV hydration, despite having lost considerable weight, the resident may not be treated against his or her wishes. If a resident is unable to make a health care decision, a decision by the resident's legal representative to forego treatment may, subject to state requirements, be equally binding on the facility. A resident may not be transferred or discharged for refusing treatment unless the criteria for transfer or discharge are otherwise met. Facility staff should attempt to determine the reason for the refusal of care, including whether a resident who is unable to verbalize their needs is refusing care for another reason such as pain, fear of a staff member, etc., and address the concern if possible. Any services that would otherwise be required but are refused must be described in the Comprehensive Care Plan. See F556. Comprehensive Care Plans for further guidance. The resident has the right to refuse to participate in experimental research. A resident being considered for participation in experimental research must be fully informed of the nature of the experimental research, for example, medication or other treatment, and the possible consequences of participating. The resident must provide informed consent prior to participation and initiation of experimental research. If the resident is incapable of understanding the situation and of realizing the risks and benefits of the proposed research, but a resident representative gives consent, facility staff have a responsibility to ensure that the consent is properly obtained and that essential measures are taken to protect the resident from harm or mistreatment. The resident or his or her representative, if the resident lacks health care decision-making capacity, must have the opportunity to refuse to participate both before and during the experimental research activity. The ability of a dying person to control decisions about medical care and daily routines has been identified as one of the key elements of quality care at the end of life. The process of advance care planning is ongoing and affords the resident, family, and others on the residence interdisciplinary health care team an opportunity to reassess the resident's goals and wishes as the resident's medical condition changes. Advanced care planning is an integral aspect of the facility's comprehensive care planning process and assures reevaluation of the resident's desires on a routine basis, and when there is a significant change in the resident's condition. The process can help the resident, family, and interdisciplinary team prepare for the time when a resident becomes unable to make decisions or is actively dying. The facility is required to establish, maintain, and implement written policies and procedures regarding the resident's right to formulate an advance directive, including the right to accept or refuse medical or surgical treatment. In addition, the facility management is responsible for ensuring that staff follow those policies and procedures. The facility's policies and procedures delineate the various steps necessary to promote and implement these rights, including, but not limited to, determining on admission whether the resident has an advance directive, and if not, determining whether the resident wishes to formulate an advance directive, providing information in a manner easily understood by the resident or resident representative about the right to refuse medical or surgical treatment and formulate an advanced directive. This includes a written description of the facility's policies to implement advanced directives and applicable state law regarding advanced directives. Determining if facility staff periodically assesses the resident for decision-making capacity and invokes health care agent or representative if the resident is determined not to have decision-making capacity. Identifying the primary decision-maker, assessing the resident's decision-making capacity, and identifying or arranging for an appropriate representative for the resident. Assessed as unable to make relevant health care decisions. Defining and clarifying medical issues and presenting the information regarding relevant health care issues to the resident or his or her representative as appropriate. Identifying, clarifying, and periodically reviewing as part of the comprehensive care planning process, the existing care instructions, and whether the resident wishes to change or continue these instructions. Identifying situations where health care decision-making is needed, such as a significant decline or improvement in the resident's condition. Establishing mechanisms for documenting and communicating the resident's choices to the interdisciplinary team and to staff responsible for the resident's care, and identifying the process as provided by state law for handling situations in which the facility staff and or physician do not believe that they can provide care in accordance with the resident's advanced directives or other wishes on the basis of conscience. If the resident or the resident's representative has executed one or more advanced directives, or executes one upon admission, copies of these documents must be obtained and maintained in the same section of the resident's medical record, readily retrievable by any facility staff. Facility staff must communicate the resident's wishes to the resident's direct care staff and physician. If the resident does not have an advance directive, facility staff must inform the resident representative of their right to establish one as set forth in the laws of the state and provide assistance if the resident wishes to execute one or more directives. Facility staff must document in the resident's medical record these discussions and any advance directives that the resident executes. The resident has the option to execute advance directives, but cannot be required to do so, as required by 42 CFR. Section 489.102A3, the facility may not condition the provision of medical care or discriminate against a resident based on whether he or she has executed an advance directive. Facility staff are not required to provide care that conflicts with an advance directive. In addition, facility staff are not required to implement an advance directive if, as a matter of conscience, the provider cannot implement an advance directive and state law allows the provider to conscientiously object. Note, other directives a resident may choose to exercise may include, but are not limited to a directive to the attending physician, a medical power of attorney, a pre-existing medical order for do not resuscitate DNR, or another document that directs the resident's health care such as do not hospitalize DNH. Several states have adopted the use of a portable and enduring order form that documents the resident's choices related to life sustaining treatments, while some states recognize documented oral instruction. Facility staff should periodically review with the resident and resident representative the decisions made regarding treatments, experimental research, and any advance directive and its provisions, as preferences may change over time. Procedures Section 483.10 C6, C8, G12. Observe for efforts on the part of facility staff to inform residents or their representative of their rights, and that information is communicated at times, it would be most useful to them, such as when they are expressing concerns or raising questions. Interview the resident's representative and facility staff to determine if residents are informed in a manner they understand of their right to request or refuse. Treatment. A resident has an advance directive, and if staff are aware of what this directive states. A resident does not have an advance directive, and if so, how the resident was informed of his or her right to develop one, and was the resident provided assistance in doing so. And staff periodically assess a resident's decision-making capacity. How often and how and by whom is this done? Review the resident's medical record to determine if the resident has an advance directive and a copy is located in the medical record, and the facility has policies and procedures to implement advance directives. Key elements of noncompliance section 483.10C6, C8, G12. To cite deficient practice at F578, the surveyor's investigation will generally show that the facility failed to do one or more of the following: provide information to the resident regarding their right to refuse medical or surgical treatment or to formulate an advance directive once the resident was able to receive the information, or honor a resident's, their family, and / or their representative's decision to request, refuse, or discontinue experimental research, or ensure that a current copy of a resident's advance directive was in the resident's medical record, or have policies and procedures for implementing advance directives, or follow policies to implement advance directives and applicable state laws regarding advance directives. Potential tags for additional consideration. Examples of some of the related requirements that may be considered when noncompliance has been identified include, but are not limited to, the following. Section 42, CFR Section 483.10A37, F551, for concerns regarding designation of resident representative. Section 42, CFR Section 483.10C23, F553, right to participate in planning care for concerns regarding the resident's right to participate in and be informed of his or her treatment. Tag F579. Section 483.10G13, the facility must display in the facility written information and provide to residents and applicants for admission oral and written information about how to apply for and use Medicare and Medicaid benefits and how to receive refunds for previous payments covered by such benefits. Definitions, Section 483.10G13. Refunds for previous payments refers to refunds due as a result of Medicaid and Medicare payments when eligibility has been determined retroactively. Guidance Section 483.10G13. To fulfill this requirement, facility staff may use written materials issued by the state Medicaid agency and the federal government relating to these benefits. Facilities may fulfill their obligation to orally inform residents or prospective residents about how to apply for Medicaid or Medicare by assisting them in working with the local Social Security office or the local unit of the state Medicaid agency. Simply providing a phone number is not sufficient in assisting resident or the resident representative. Facilities are not responsible for orally providing detailed information about Medicare and Medicaid eligibility rules. Tag F580. Section 483.10G14, notification of changes. A facility must immediately inform the resident, consult with the resident's physician, and notify, consistent with his or her authority, the resident Representative S when there is A. An accident involving the resident which results in injury and has the potential for requiring physician intervention. B. A significant change in the resident's physical, mental, or psychosocial status. That is, a deterioration in health, mental, or psychosocial status in either life. Threatening conditions or clinical complications. C. A need to alter treatment significantly, that is, a need to discontinue an existing form of treatment due to adverse consequences or to commence a new form of treatment, or D. A decision to transfer or discharge the resident from the facility as specified in Section 483.1, 5C1 Roman 2. Roman 2. When making notification under paragraph G14I of this section, the facility must ensure that all pertinent information specified in Section 483.1, 5C2 is available and provided upon request to the physician. Roman 3. The facility must also promptly notify the resident and the resident representative, if any, when there is A change in room or roommate assignment, as specified in Section 483.10E6, or B. A change in resident rights under federal or state law or regulations, as specified in paragraph E10 of this section. Roman 4. The facility must record and periodically update the address, mailing, and email and phone number of the resident representative S. Section 483.1, 0G15. Admission to a composite distinct part. A facility that is a composite distinct part as defined in Section 483.5 must disclose in its admission agreement its physical configuration, including the various locations that comprise the composite distinct part, and must specify the policies that apply to room changes between its different locations under Section 483.1, 5C9. Definitions, Section 483.1, 0G14. A need to alter treatment significantly means a need to stop a form of treatment because of adverse consequences, such as an adverse drug reaction, or commence a new form of treatment. To deal with a problem, for example, the use of any medical procedure or therapy that has not been used on that resident before. Guidance Section 483.1, 0G14. While the regulatory obligation is not limited to these symptoms, physician notification should occur when a resident experiences symptoms such as chest pain, loss of consciousness, or other signs or symptoms of heart attack or stroke that may signify a significant change. Even when a resident is mentally competent, his or her designated resident representative or family, as appropriate, should be notified of significant changes in the resident's health status. Because the resident may not be able to notify them personally, especially in the case of sudden illness or accident. If the resident is not capable of making decisions, facility staff must contact the designated resident representative, consistent with his or her authority, to make any required decisions, but the resident must still be told what is happening to him or her. In the case of the death of a resident, the resident's physician is to be notified immediately by facility staff in accordance with state law. If there is a deficiency specific to the requirement at Section 483.10G15, do not cite here, but cite under Section 483.1, 5A17, F620, regarding admission policies. Tag F581. This tag number is in reserve for future use, and there will be no citations under this tag. Tag F582. Section 483.1, 0G17. The facility must inform each Medicaid-eligible resident, in writing, at the time of admission to the nursing facility, and when the resident becomes eligible for Medicaid, of A. The items and services that are included in nursing facility services under the state plan and for which the resident may not be charged. B. Those other items and services that the facility offers and for which the resident may be charged, and the amount of charges for those services. And II. Inform each Medicaid-eligible resident when changes are made to the items and services specified in Section 483.10 G17IA and B of this section. Section 483.10 G18, the facility must inform each resident before or at the time of admission and periodically during the resident's stay of services available in the facility and of charges for those services, including any charges for services not covered under Medicare/Medicaid or by the facility's per diem rate. I. Where changes in coverage are made to items and services covered by Medicare and / or by the Medicaid state plan, the facility must provide notice to residents of the change as soon as is reasonably possible. II. Where changes are made to charges for other items and services that the facility offers, the facility must inform the resident in writing at least 60 days prior to implementation of the change. III. If a resident dies or is hospitalized or is transferred and does not return to the facility must refund to the resident representative, or estate, as applicable, any deposit or charges already paid, less the facility's per diem rate for the days the resident actually resided or reserved or retained a bed in the facility, regardless of any minimum stay or discharge notice requirements. IV. The facility must refund to the resident or resident representative any and all refunds due the resident within 30 days from the resident's date of discharge from the facility. V. The terms of an admission contract by or on behalf of an individual seeking admission to the facility must not conflict with the requirements of these regulations. Definitions. Section 483.10 G1718. Periodically means whenever changes are being introduced that will affect the resident's liability and whenever there are changes in services. Guidance. Section 483.10 G1718. Residents must be told in advance when changes will occur in their bills. Providers must fully inform the resident of services and related changes. A Medicare beneficiary who requires services upon admission that are not covered under Medicare may be required to submit a deposit, provided the notice provisions of Section 483.10 G17, if applicable, are met. Facility staff must notify residents of services or items that they may be charged for if they are not required by the resident's care plan, such as hair salon services. Beyond basic services or incontinence briefs, the resident requests per personal preference in lieu of the briefs provided by the facility. See Section 483.10 F11 for those items and services that must be included in payment under skilled nursing and nursing facility benefits. The facility's responsibility regarding refunds applies to all residents for any deposit or charges already paid by a resident during their nursing home stay. For residents residing in a continuing care retirement community CCRC, an exception can be considered for those residents who were admitted to the CCRC's nursing home, had deposits and charges related to the CCRC, separate from those incurred during the nursing home stay, and who were discharged/transferred from the nursing home back to the same CCRC's independent or assisted living residences. Beneficiary notices. 1. Notice of Medicare Non-Coverage NOMC. The NOMC, Forms CMS 10123, is given by the facility to all Medicare beneficiaries at least 2 days before the end of a Medicare covered Part A stay, or when all of Part B therapies are ending. The NOMC informs the beneficiaries of the right to an expedited review by a quality improvement organization. See also 42 CFR 405.1200 and 422.624. The NOMC is not given if the beneficiary exhausts the SNF benefits coverage 100 days, thus exhausting their Medicare Part A SNF benefit. The beneficiary initiates the discharge from the SNF. The beneficiary elects the hospice benefit or decides to revoke the hospice benefit and return to standard Medicare coverage. 2. Skilled Nursing Facility Advanced Beneficiary Notice of Non-Coverage SNF ABN. It is important to note that the SNF ABN, CMS 10055, is only issued if the beneficiary intends to continue services, and the SNF believes the services may not be covered under Medicare. It is the facility's responsibility to inform the beneficiary about potential non-coverage and the option to continue services with the beneficiary, accepting financial liability for those services. Per CH 30, Section 70.2 of the Medicare Claims Processing Manual IMPUB 100-04A. SN FABN must be given to a beneficiary for the following triggering events. Initiation in the situation in which a SNF believes Medicare will not pay for extended care items or services that a physician has ordered. The SNF must provide a SN FABN to the beneficiary before it furnishes those non-covered extended care items or services to the beneficiary. Reduction in the situation in which a SNF proposes to reduce a beneficiary's extended care items or services because it expects that Medicare will not pay for a subset of extended care items or services, or for any items or services at the current level in or frequency of care that a physician has ordered. The SNF must provide a SN FABN to the beneficiary before it reduces items or services to the beneficiary. Termination in the situation in which a SNF proposes to stop furnishing all extended care items or services to a beneficiary because it expects that Medicare will not continue to pay for the items or services that a physician has ordered and the beneficiary would like to continue receiving the care. The SNF must provide a SNF ABN to the beneficiary before it terminates such extended care items or services. The SNF ABN provides information to beneficiaries so that they can decide if they wish to continue receiving the skilled services that may not be paid for by Medicare and assume financial responsibility. If the SNF provides the beneficiary with the SNF ABN, the facility has met its obligation to inform the beneficiary of his or her potential financial liability and related standard claim appeal rights. The SNF files a claim when requested by the beneficiary. This claim is called a demand bill and may not charge the beneficiary for Medicare covered Part A services during demand bill process. For detailed information, refer to the Medicare Claims Processing Manual IMPUB 100-04 at https://www.cmsgov/regulations and guidance/manuals/downloads/CLM 104C30 PDF. SN FABN is addressed in CH 30. Section 70 of the manual and NOMC is addressed in Section 260. Note: a facility's requirement to notify and explain via the SN FABN that the individual is no longer receiving Medicare Part A services based on the SNF's belief that Medicare Part A will not pay for the resident stay is separate and unrelated to the admission and discharge requirements under 42 CFR Section 483.15, which outlines the notification and requirements under which an individual may be discharged from the facility, or when the transfer or discharge is not initiated by the resident. Key elements of noncompliance section 483.10 G1718. To cite deficient practice at F582, the surveyor's investigation will generally show the facility failed to do one or more of the following. Notify each Medicaid-eligible resident in writing of the items and services which are not covered under Medicaid or by the facility's per diem rate, including the cost of those items and services. O at the time of admission, or O when the resident became eligible for Medicaid, or inform each Medicaid-eligible resident when changes were made to the items and services covered by Medicaid, or inform each resident of services available in the facility and the charges for those services not covered under Medicare/Medicaid or by the facility's per diem rate. O before admission or at the time of admission and periodically during the residence stay, or O as soon as reasonably possible when a change in coverage occurs, or O at least 60 days prior to implementation of changes made to charges for other items and services that the facility offers, or refund the applicable funds to the resident representative, or estate when a resident died or was hospitalized or was transferred and did not return to the facility, or refund any and all funds due the resident. O within 30 days from the date of discharge, or O to the resident or resident representative, or included terms in the admission contract that conflicted with the requirements of these regulations. Tag F583. Section 483.10 H Privacy and Confidentiality. The resident has a right to personal privacy and confidentiality of his or her personal and medical records. Section 483.10 HL Personal privacy includes accommodations, medical treatment, written and telephone communications, personal care, visits, and meetings of family and resident groups, but this does not require the facility to provide a private room for each resident. Section 483.10 H2, the facility must respect the resident's right to personal privacy, including the right to privacy in his or her oral, that is, spoken, written, and electronic communications, including the right to send and promptly receive unopened mail and other letters, packages, and other materials delivered to the facility for the resident, including those delivered through a means other than a postal service. Section 483.10 H3, the resident has a right to secure and confidential personal and medical records. The resident, has the right to refuse the release of personal and medical records, except as provided at Section 483.70 H2 or other applicable federal or state laws. Roman 2. The facility must allow representatives of the Office of the State Long-Term Care Ombudsman to examine a resident's medical, social, and administrative records in accordance with state law. Definitions, Section 483.10 H. Confidentiality is defined as safeguarding the content of information, including video, audio, or other computer-stored information from unauthorized disclosure without the consent of the resident and / or the individual's surrogate or representative, if there is information considered too confidential to place in the record used by all staff, such as the family's financial assets or sensitive medical data. It may be retained in a secure place in the facility, such as a locked cabinet in the administrator's office. The record must show the location of this confidential information. Promptly means delivery of mail or other materials to the resident within 24 hours of delivery by the Postal Service including a post office box and delivery of outgoing mail to the postal service within 24 hours, except when there is no regularly scheduled postal delivery and pickup service. Right to personal privacy includes the resident's right to meet or communicate with whomever they want without being watched or overheard. Private space may be created flexibly and need not be dedicated solely for visitation purposes. Guidance Section 483.10H. Each resident has the right to privacy and confidentiality for all aspects of care and services. A nursing home resident has the right to personal privacy of not only his or her own physical body, but of his or her personal space, including accommodations and personal care. Residents in nursing homes have varying degrees of physical/psychosocial needs, intellectual disabilities, and/or cognitive impairments. A resident may be dependent on nursing home staff for some or all aspects of care, such as assistance with eating, ambulating, bathing, daily personal hygiene, dressing, and bathroom needs. Only authorized staff directly involved in providing care and services for the resident may be present when care is provided, unless the resident consents to other individuals being present during the delivery of care. During the delivery of personal care and services, staff must remove residents from public view, pull privacy curtains or close doors, and provide clothing or draping to prevent exposure of body parts. Photographs or recordings of a resident and/or his or her private space without the resident's or designated representative's written consent is a violation of the resident's right to privacy and confidentiality. Examples include, but are not limited to, staff taking unauthorized photographs of a resident's room or furnishings, which may or may not include the resident or a resident eating in the dining room, or a resident participating in an activity in the common area, taking unauthorized photographs or recordings of residents in any state of dress or undress, using any type of equipment, for example, cameras, smartphones, and other electronic devices, and/or keeping or distributing them through multimedia messages or on social media networks is a violation of a resident's right to privacy and confidentiality. Personal and medical records include all types of records the facility might keep on a resident, whether they are medical, social, fund accounts, automated, electronic, or other. Care must be taken to protect the privacy of personal information on all residents, including gender identity and sexual orientation. Posting signs in residents' rooms or in areas visible to others that include clinical or personal information could be considered a violation of a resident's privacy. It is allowable to post signs with this type of information in more private locations not visible to the public. An exception can be made in an individual case if a resident or his or her representative requests the posting of information at the bedside, such as instructions to not take blood pressure in right arm. This does not prohibit the display of resident names on their doors, nor does it prohibit display of resident memorabilia and/or biographical information in or outside their rooms with their consent, or the consent of his or her representative. This does not include isolation precaution information for public health protection, as long as the sign does not reveal the type of infection. Personal resident information must be communicated in a way that protects the confidentiality of the information and the dignity of residents. This includes both verbal and written communications, such as the presence of lists of residents with certain conditions, such as incontinence and pressure ulcers at nursing stations in view, or in hearing of residents and visitors. This does not include clinical information written in a resident's record. Privacy for visitation or meetings might be arranged by using a dining area between meals. A vacant chapel, office, or room, or an activities area when activities are not in progress. Arrangements for private space could be accomplished through cooperation between the facility's administration and resident or family groups so that private space is provided for those requesting it without infringement on the rights of other residents. All residents have the right to privacy in their communications, including justice involved. Residents, additional guidance on mail, telephone, electronic communications, and visitation. Rights are addressed in Section 483.10 G69, F576, and Section 483.10 F4IAG, F562. C. Section 483.90 E1 Roman 4, F914, for full visual privacy around beds. With the exception of the explicit requirement for privacy curtains in all initially certified facilities, see Section 483.90 E1V, F914, the facility is free to innovate to provide privacy for its residents. This may but need not be through the provision of a private room. Procedures, Section 483.10 H. Observe for situations where facility staff may not be honoring the resident's privacy, including during visits, treatment, or leaving medical records out for public view. During interviews with residents, their representatives, visitors, or families determine if their privacy has been honored by facility staff. Interview the representative of the Office of the State Long-Term Care Ombudsman, who serves residents of the facility, to determine if the facility allows him/her to examine the resident's records with the permission of the resident or resident representative, or as otherwise authorized by state law. Are there signs regarding care information posted in view in residents' rooms? If these are observed, determine if such signs are there by resident or resident representative. Direction. If so, these signs are allowable. Is personal resident information communicated in a way that protects the confidentiality of the information and the dignity of residents? If concerns are found, interview staff regarding facility policy or procedures regarding protecting resident privacy and confidentiality. Tag F584. Section 483.10 I Safe Environment. The resident has a right to a safe, clean, comfortable, and home-like environment, including, but not limited to, receiving treatment and supports for daily living safely. The facility must provide. Section 483.10 I1, a safe, clean, comfortable, and home-like environment, allowing the resident to use his or her personal belongings to the extent possible. This includes ensuring that the resident can receive care and services safely and that the physical layout of the facility maximizes resident independence and does not pose a safety risk. Roman 2, the facility shall exercise reasonable care for the protection of the residents' property from loss or theft. Section 483.10 I2, housekeeping and maintenance services necessary to maintain a sanitary, orderly, and comfortable interior. Section 483.10 I3, clean bed and bath linens that are in good condition. Section 483.10 I4, private closet space in each resident room, as specified in Section 483.90 E2 Roman 4. Section 483.10 I5, adequate and comfortable lighting levels in all areas. Section 483.10 I6, comfortable and safe temperature levels. Facilities initially certified after October 1, 1990 must maintain a temperature range of 71 to 81 F, and Section 483.10 I7 for the maintenance of comfortable sound levels. Definitions, Section 483.10I. Adequate lighting means levels of illumination suitable to tasks the resident chooses to perform or the facility staff must perform. Comfortable lighting means lighting that minimizes glare and provides maximum resident control, where feasible, over the intensity, location, and direction of lighting to meet their needs or enhance independent functioning. Comfortable and safe temperature levels means that the ambient temperature should be in a relatively narrow range that minimizes residents' susceptibility to loss of body heat and risk of hypothermia or hyperthermia, and is comfortable for the residents. Comfortable sound levels do not interfere with residents' hearing and enhance privacy when privacy is desired and encourage interaction when social participation is desired. Of particular concern to comfortable sound levels is the residents' control over unwanted noise. Environment refers to any environment in the facility that is frequented by residents, including but not limited to the residents' rooms, bathrooms, hallways, dining areas, lobby, outdoor patios, therapy areas, and activity areas. A home-like environment is one that de-emphasizes the institutional character of the setting to the extent possible and allows the resident to use those personal belongings that support a home-like environment. A determination of home-like should include the resident's opinion of the living environment. Orderly is defined as an uncluttered physical environment that is neat and well-kept. Sanitary includes, but is not limited to, preventing the spread of disease-causing organisms by keeping resident care equipment clean and properly stored. Resident care equipment includes, but is not limited to, equipment used in the completion of the activities of daily living. Guidance Section 483.10I. A personalized, home-like environment recognizes the individuality and autonomy of the resident, provides an opportunity for self-expression, and encourages links with the past and family members. The intent of the word home-like in this regulation is that the nursing home should provide an environment as close to that of the environment of a private home as possible. This concept of creating a home setting includes the elimination of institutional odors and practices to the extent possible. Some practices that can be eliminated to decrease the institutional character of the environment include, but are not limited to, the following: overhead paging, including frequent announcements and piped-in music throughout the building. Meal service using trays. Some residents may wish to eat certain meals on trays. Institutional signs labeling workrooms/closets in areas visible to residents and the public. Medication or treatment carts. Some innovative facilities store medications in locked areas in resident rooms or in secured carts that appear like furniture. The widespread and long-term use of audible chair and bed alarms instead of their limited use for selected residents for diagnostic purposes or according to their care planned needs. These devices can startle the resident and constrain the resident from normal repositioning movements, which can be problematic. Furniture that does not reflect a home-like environment or is uncomfortable. The absence of window treatments or drapes, the lack of textures, or the absence of bedspreads or personal items in rooms or on walls. Large, centrally located nursing/care team stations, including those with barriers such as plexiglass that prevent the staff from interacting with residents. Many facilities cannot immediately make these types of changes, but it should be a goal for all facilities that have not yet made these types of changes to work toward them. A nursing facility is not considered non-compliant if it still has some of these institutional features, but the facility is expected to do all it can within fiscal constraints to provide an environment that enhances quality of life for residents, in accordance with resident preferences. A home-like environment is not achieved simply through enhancements to the physical environment. It concerns striving for person-centered care that emphasizes individualization, relationships, and a psychosocial environment that welcomes each resident and makes her/him comfortable. It is the responsibility of all facility staff to create a home-like environment and promptly address any cleaning needs. In a facility in which most residents come for a short-term stay, residents would not typically move his or her bedroom furniture into the room, but may desire to bring a television, chair, or other personal belongings to have while staying in the facility. There needs to be sufficient individual closet space so that resident clothing is kept separate from a roommate's. Closets must be structured so the resident can get to and reach their hanging clothing whenever they choose. Out-of-season items may be stored in alternate locations outside the resident's room. Adequate lighting design has these features. Lighting with minimum glare in areas frequented by residents. Elimination of high levels of glare produced by shiny flooring and from unshielded window openings. Even light levels in common areas and hallways, avoiding patches of low light caused by too much space between light fixtures, within limits of building design constraints. Use of daylight as much as possible. Extra lighting, such as table and floor lamps to provide sufficient light to assist residents with tasks such as reading. Lighting for residents who need to find their way from bed to bathroom at night. For example, red-colored nightlights preserve night vision, and dimming switches in resident rooms where possible and when desired by the resident, so that staff can tend to a resident at night with limited disturbances to them or a roommate. If dimming is not feasible, another option may be for staff to use flashlight/pen lights when they provide night care. While facilities certified after October 1, 1990 are required to maintain an air temperature range of 71 to 81 F, there may be brief periods of time where that temperature falls outside of that range. Only during rare, brief periods of unseasonable weather. This interpretation would apply in cases where it does not adversely affect resident health and safety, and facility staff took appropriate steps to ensure resident comfort. This would enable facilities in areas of the country with relatively cold or hot climates to avoid the expense of installing equipment that would only be needed infrequently. Procedures Section 483.10I. Verify the air temperature above floor level in resident rooms, dining areas, and common areas. If the temperature is out of the 71 to 81 F range, then ask staff what actions they take when residents complain of heat or cold, such as providing extra fluids during heat waves and extra blankets and sweaters in cold. During interviews, ask residents and families whether they think the facility is as home-like as possible and whether they have been encouraged to bring in personal property items within space constraints. Observe bedrooms of sampled residents for personalization. Does the room tell the survey team anything about the resident's everyday life and interests? Observe for personal items such as family photographs, books and magazines, etc. that belong to the residents, for residents who have no relatives or friends or few assets. Has facility staff assisted these residents to make their rooms home-like if they so desire? If potential issues are discovered, ask staff about their efforts to provide a home-like environment. Determine if the resident's preferences are honored, or is the facility's goal of having a sanitary, safe, and uncluttered environment preventing the resident from having an individualized area. Observe and question sampled residents throughout the survey and note if they are having difficulty reading or doing tasks due to insufficient lighting, or if they are wearing sunglasses or Visors indoors due to glare, if they have difficulty seeing food on their plate, experiencing squinting or shading their eyes from glare or other signs that lighting does not meet their needs. Probes Section 483.10I. Does the resident have any concerns with lighting, noise, temperature, or anything else that may affect their comfort? Are resident care areas and equipment kept clean and in good repair? Does the resident's room appear cluttered and disorderly, with a lack of storage for clothing, belongings, or personal care equipment? Are areas of the facility used by residents designed or organized to ensure the resident can receive care and services safely without risk of falling or injury while maximizing resident independence? Do window treatments, bed linens, towels, privacy curtains, etc. appear clean and in good condition? How does facility staff ensure resident personal property is kept safe from loss or theft? Potential tags for additional consideration. Examples of some of the related requirements that may be considered when non-compliance has been identified include, but are not limited to, the following. For concerns regarding the resident's right to have personal possessions, including furnishings, see Section 483.10E2, F557. For concerns related to misappropriation of resident property, see Section 483.12, F602. Misappropriation of resident property. For issues of safety of the environment, presence of hazards and hazardous practices, see Section 483.25D, F689, Accidents. For kitchen sanitation, see Section 483.60I, F812, Food safety requirements. For facility-wide sanitary practices affecting the quality of care, see Section 483.80, F880. Infection control. For issues of fire danger, see guidance provided for Section 483.90A, which states 4. Additional guidance on life safety from fire and the survey procedures for these regulatory requirements, reference Appendix I in the SOM. Concerns regarding the above regulatory provisions would be addressed through the Life Safety Code Survey K tags, or for issues of cleanliness of areas of the facility used by staff, only such as the break room, medication room, laundry, kitchen, etc., or the public only such as the parking lot, see Section 483.90H, F921, Other Environmental Conditions. Tag F585. Section 483.10J Grievances. Section 483.10J1. The resident has the right to voice grievances to the facility or other agency or entity that hears grievances without discrimination or reprisal, and without fear of discrimination or reprisal. Such grievances include those with respect to care and treatment which has been furnished as well as that which has not been furnished, the behavior of staff and of other residents, and other concerns regarding their LTC facility. Stay. Section 483.10J2. The resident has the right to, and the facility must make prompt efforts by the facility to resolve grievances the resident may have, in accordance with this paragraph. Section 483.10J3. The facility must make information on how to file a grievance or complaint available to the resident. Section 483.10J4. The facility must establish a grievance policy to ensure the prompt resolution of all grievances regarding the resident's rights contained in this paragraph. Upon request, the provider must give a copy of the grievance policy to the resident. The grievance policy must include I. Notifying resident individually or through postings in prominent locations throughout the facility of the right to file grievances orally, meaning spoken or in writing, the right to file grievances anonymously, the contact information of the grievance official with whom a grievance can be filed, that is, his or her name, business address, mailing and email, and business phone number, a reasonable expected time frame for completing the review of the grievance, the right to obtain a written decision regarding his or her grievance, and the contact information of independent entities with whom grievances may be filed, that is, the pertinent state agency, quality improvement organization, state survey agency, and state long-term care ombudsman program or protection and advocacy system. Roman 2, identifying a grievance official who is responsible for overseeing the grievance process, receiving and tracking grievances through to their conclusions, leading any necessary investigations by the facility, maintaining the confidentiality of all information associated with grievances, for example, the identity of the resident for those grievances submitted anonymously, issuing written grievance decisions to the resident, and coordinating with state and federal agencies as necessary in light of specific allegations. Roman 3, as necessary, taking immediate action to prevent further potential violations of any resident right while the alleged violation is being investigated. Roman 4, consistent with Section 483.12c1, immediately reporting all alleged violations involving neglect, abuse, including injuries of unknown source, and / or misappropriation of resident property by anyone furnishing services on behalf of the provider to the administrator of the provider, and as required by state law. V. Ensuring that all written grievance decisions include the date the grievance was received, a summary statement of the resident's grievance, the steps taken to investigate the grievance, a summary of the pertinent findings or conclusions regarding the resident's concerns, a statement as to whether the grievance was confirmed or not confirmed, any corrective action taken or to be taken by the facility as a result of the grievance, and the date the written decision was issued. Roman 6, taking appropriate corrective action in accordance with state law if the alleged violation of the resident's rights is confirmed by the facility or if an outside entity having jurisdiction, such as the state survey agency, quality improvement organization, or local law enforcement agency confirms a violation for any of these residents' rights within its area of responsibility, and Roman 7, maintaining evidence demonstrating the result of all grievances for a period of no less than 3 years from the issuance of the grievance decision. Intent Section 483.10J. To support each resident's right to voice grievances, such as those about treatment, care, management of funds, lost clothing, or violation of rights, and to ensure that a policy is in place. To process grievances, facility staff are responsible for making prompt efforts to resolve a grievance and to keep the resident appropriately apprised of progress toward resolution. Definitions, Section 483.10J. Prompt efforts to resolve include facility acknowledgement of a complaint/grievance and actively working toward resolution of that complaint/grievance. Procedures, Section 483.10J. If a resident's response indicates problems in voicing grievances and getting grievances resolved, determine how facility staff deal with and make prompt efforts to resolve resident complaints and grievances. With permission from the resident council, president, or officer, review resident council minutes. Interview staff about how grievances are handled. How does facility staff protect residents from discrimination or reprisal when a grievance is voiced? How does facility staff ensure the right of the residents to file a grievance anonymously is Supported. Interview staff about communication with resident regarding progress toward resolution of complaint/grievance. Review facility grievance policy to see if compliant with necessary requirements as listed above. Determine how information on how to file a grievance is made available to the resident. Review grievance decisions to determine if required information was provided to. Residence and facility documentation was maintained for at least 3 years. Potential tags for additional investigation. If the facility failed to allow a resident to exercise his or her right to file a grievance, including the right to file an anonymous grievance without interference, coercion, discrimination, or reprisal from the facility, see guidance at Section 483.10b1, F550, Resident Rights and Dignity. If facility staff failed to report all alleged violations involving neglect, abuse, including injuries of unknown source, and / or misappropriation of resident property, see guidance at Section 483.12c1. 4. F609, Reporting of Alleged Violations. Key elements of noncompliance section 483.10j. To cite deficient practice at F585, the surveyor's investigation will generally show that the facility failed to do one or more of the following. Support the resident's right to voice any grievance without discrimination, reprisal, or the fear of discrimination or reprisal, or make prompt efforts to resolve the resident's grievance, or make information on how to file a grievance or complaint available to the resident, or establish a grievance policy that includes notifying the resident individually or with prominent postings throughout the facility about the right to file a grievance in writing or orally, the right to file a grievance anonymously, the reasonable time frame the resident can expect a completed review of the grievance, the right to obtain the review in writing, the required contact information of the grievance official, the contact information of independent entities with whom grievances may also be filed, or identify the grievance official, or prevent any further potential violation of any resident right during the grievance. Review if necessary, or immediately report certain violations as required by state law to the administrator, or ensure written grievance decisions meets documentation requirements, or take appropriate corrective action in accordance with state law if the grievance is confirmed by the facility or an outside entity having jurisdiction, or maintain evidence of the result of all grievances for no less than 3 years from the date the grievance decision was issued. Tag F586. Section 483.1, 0K Contact with external entities. A facility must not prohibit or in any way discourage a resident from communicating with federal, state, or local officials, including, but not limited to, federal and state surveyors, other federal or state health department employees, including representatives of the Office of the State Long-Term Care Ombudsman, and any representative of the agency responsible for the protection and advocacy system for individuals with mental disorder, established under the Protection and Advocacy for Mentally Ill Individuals Act of 2042, USC 10801 et seq., regarding any matter, whether or not subject to arbitration or any other type of judicial or regulatory action. Intent Section 483.10K. Facility staff must ensure that residents are able to communicate freely with representatives of these entities for whatever matter. If concerns are identified regarding being provided contact information for representatives of these entities, See guidance at 42 CFR section 483.10J4I. F585, grievances. This concludes the reading of Appendix PP. Regulation Section 483.10, tags F550 through F586.